do not touch the button signs. That's smart. Okay, good afternoon, Chairman Wilson, Vice Chair Crosby, and esteemed members of the Economic Matters Committee. Thank you for this opportunity to present HB 747, which prohibits the sale of general purpose fluorescent light bulbs. This is my second year bringing this. For the record, I'm Delegate Jen Terrassa, and for many years, fluorescent lighting was considered to be more efficient than the alternatives and was preferred for many indoor spaces. But now we know LED light bulbs are the safer, more cost-effective alternative. Fluorescent bulbs contain mercury and are bad for the environment. The General Assembly recognized this in 2009 with legislative findings that, among other things, that mercury is a persistent toxic pollutant that bioaccumulates in the environment. Consumption of mercury contaminated fish poses a significant health threat. Accidental mercury spills and breakages and release have occurred at schools in the United States, exposing students, teachers, administrators to mercury emission, among other things. And in fact, Maryland has already phased out the sale of many other items containing mercury, like thermostats and switches. And while fluorescent bulbs used to be seen as the most efficient lighting, we now know LEDs are much more efficient than fluorescent bulbs. In fact, twice as efficient, using half the amount of electricity and the same amount of light and lasting twice as long. Use of LEDs instead also reduces emission released by power plants, helping to mitigate ongoing climate change. Fluorescent bulbs pose a personal safety risk, especially for workers. When bulbs break, mercury vapor is released into the air. This creates a significant health hazard to those nearby. And human exposure to mercury can result in nervous system, kidney, and liver damage and impaired childhood development. From the user's perspective, you are at risk every time you change or dispose of mercury bulbs. Think about it. What do you do when you change a fluorescent bulb? Have you ever dropped a light bulb? If you have thrown them in the trash, have they been crushed in the trash, exposing your family and community to mercury? And from a worker perspective, unlike home customers, they have no choice about the bulbs. They handle those that their employers supply. Therefore, those workers replace bulbs and handle trash containing used fluorescent bulbs, like maintenance staff and others that have dangerous levels of mercury. Disposing of fluorescent bulbs is complicated because technically they should be only disposed of as hazardous waste, but most of the time, as you probably know, that's not done. This puts trash workers and landfill workers at risk of exposure to mercury and also leaves contaminated waterways. So while individual LED bulbs let me just address the cost issue. While individual LED bulbs may cost slightly more to purchase than fluorescent bulbs on average, LEDs cost far less to operate. In residential settings, any slight additional cost associated with LEDs is made up for in that cost is made up for in the savings from reduced energy costs. The bigger savings comes from commercial settings. Here, LED bulbs are only 11% more expensive than fluorescent bulbs, but $24 per bulb saved on electric bills. And note, LED bulbs are designed to be put into the same fixtures. That's really important. So the vast majority of cases, there's no need for any infrastructure change. So what does this bill do? HB 747 will stop the sale of screw-in, bayonet, and compact fluorescent light bulbs. I have pictures of those. You just hold those up, just so you see what those three are in case you don't know. The bill has exemptions for bulbs that are needed for special uses like copy machines, automotive, medical, and scientific purposes. Other states have similar bans. HB 747 will help Marylanders save money, reduce exposure to dangerous mercury. So I just want to make a really quick note before I go. Just quickly want to address NIOP's opposition, which surprised me because they were favorable with the amendment last year. The concerns they raised last year, and I think this year, is they want a slower phase out of fixtures. However, this bill does not address fixtures. There's no ban on fixtures, and it's important that LED bulbs can fit in the same fixtures. So there's not a need to change out those fixtures until those fixtures need to be changed out anyway. They also want to delay for linear bulbs, and they raise concerns about supply. However, nothing in this bill requires bulbs to be disposed of until the bulb dies on its own. Then you just replace it like you would any other bulb. So there's not a mad rush to buy all new bulbs when this becomes effective. And they have known that this bill is coming for years, since we've had it a couple of years. Anyway, I respectfully urge a favorable report. Thank you.
Thank you, Mr. Chair. My name is Emily Scar. I'm the director of Maryland PIRG, the statewide consumer group, here in support of HB 747. I just want to highlight a couple of things the delegate talked about. Saying farewell to fluorescence is really a win-win-win. It's going to reduce toxic mercury exposure for our families as well as workers, help lower utility bills, and reduce air pollution from energy efficiency. LED lighting is readily available, far superior, and can be easily swapped in fluorescent lights, which is why the market and states are moving towards phasing them out. LED lighting has already taken over most of the home lighting marketplace, so your screw-in bulbs, but the market does need a push to phase out the use of fluorescent tube lights, especially those you might find in office buildings, your basement, your garage. Fluorescent light bulbs covered by this bill are not manufactured in Maryland. In fact, none are even manufactured in the US. LEDs are approximately use half the electricity of fluorescents and last twice as long, making them the economical choice. And as you can see from the bill, there are some exceptions for specific types of bulbs that do not yet have LED alternatives. Since 2022, 7 states, California, Colorado, Hawaii, Maine, Oregon, Rhode Island, and Vermont have phased out the sale of most fluorescent bulbs by passing similar legislation to this. And if Maryland delays action too much, we're likely to become a dumping ground for fluorescent lighting, which isn't good for consumers or our solid waste workers. So we urge a favorable report.
Chair Wilson, members of the committee, my name is Josh McClenny. I work for the Appliance Standards Awareness Project. I'm here to speak in support of HB 747 and reinforce that LED technology is affordable, reliable, and ready to go. ASAP published a report in 2022 evaluating the lighting market, asking that very question, are LEDs ready? We found that the answer is yes. They are now widely available and cost-effective as alternatives to fluorescent light bulbs. We found that LEDs are twice as energy efficient, which generates significant electricity bill savings. They last 2 to 3 times as long. And of course, they don't contain mercury by design. Not only did we find that LEDs are ready to go operationally, but they're widely available. LEDs are designed to be drop-in replacements for fluorescents. So in most cases, you can just take out your fluorescent and pop in an LED. We found that LEDs are better for folks' back pockets. They've come down in price dramatically in the last 10 years. Statewide, ASAP calculates that by 2050, Maryland could see a cumulative savings of $759 million in utility bill savings. I want to reiterate that LEDs save consumers and businesses money, they reduce energy use, and no one is required to change out existing bulbs as a result of this bill. Since 2022, 7 different states have passed nearly identical policies ending the sales of common fluorescent light bulbs because of the findings that LEDs are now widely available and cost-effective as replacements. I hope Maryland will join them. Thank you.
All right. Chair Wilson, members of the committee, I am Emily Ranson with Clean Water Action here in support of House Bill 747. Mercury is very toxic for human and environmental health, especially for children. Reducing mercury where we can is an important step to reducing hazardous exposure. When mercury bulbs are improperly disposed, as happens with an estimated 75% of bulbs, mercury can leach from the landfill, or if it's sent to an incinerator and burned, it is sent up into the atmosphere where it can then deposit into wetlands. In wetlands, in the anoxic or oxygen deprived environments, those conditions are ripe to create methyl mercury. That is the more toxic bioaccumulative and more toxic version of mercury. And that is one of the ones that we are very concerned about in terms of it being present in fish and accumulating up through the food chain. Maryland has taken similar steps to reducing mercury, including banning mercury switches in car trunks, mercury switches in relays more generally, and mercury thermometers. So we think that it's time for Maryland can really lead on this issue and follow some of the other states that have reduced yet another source of mercury and prevent our state from being an attractive environment for all of these unnecessary mercury bulbs. Thank you.
Thank you, Mr. Chair. Real quick, I think all of you pretty much alluded to the regular fluorescent can be changed out in most cases. What are the incidents or instances where it can't be easily switched out, just so we have a frame of reference?
So there are certain cases in which a fluorescent ballast, which is a piece of technology that converts electricity to a level that a fluorescent light can use, has to be bypassed in order to allow the LED to operate within a fixture. ASAP did savings analysis and found that in all but one case in a residential setting, incorporating the cost of a ballast bypass still saves the consumer money. The one case that we found consumers don't save money was an 8-foot tube, which is a pretty rare type of lamp that you'd see in a residential setting. So it has to do with the ballast, and in all cases but that one, it still saves consumers money to go through that process.
I guess, okay. On the, where am I putting this ballast in? Like, walk me through like an everyday life example, right? Like,
Yeah, so I wish I had a larger picture to show, but if you look up, like imagine you're in a school or an office building, and you see those receptacles that will often carry like 2 of those longer tube lights.
the tubes.
Yes, exactly. That's what we're talking about. That housing contains the ballast, and you would bypass that housing to allow the LED just to plug straight in.
Okay. All right. And then you can just basically get your light for $10 or whatever right here that I'm looking at.
Whatever the cost would be, yeah.
Okay. Yeah, I think yeah, you need an attachment, right? That's the way I understand. Basically, the ballast is the attachment in some form. It converts it or.
You would, when you bypass the ballast, there is a connection you make directly to the wiring inside of the building that connects to your LED. And we factored in all of that materials cost into our savings analysis.
Okay.
And so when you say bypass the ballast, is that we have to bring an electrician in? Is this something that can be done? I want to step back again when you're, because we're thinking, depending on your age, those tube lights, they're in the schools per se. So are you saying that you need to bring an electrician in, or is that an adapter that you would place onto the end of the new LED bulb?
You would need to bring in an electrician to do the rewiring, or someone who's potentially handy could do it themselves.
Thank you, Mr. Chairman. So it would apply to homeowners too, if you had those same fluorescent lighting tubes in a building somewhere in your house?
Again, we have found that in most cases, I believe 90% for the most common types of
It's just
linear.
a yes or no question. Does it apply to homeowners as well if they have those fluorescent tubes in their house?
Again, it depends on the type of tube, but some homeowners would
I mean,
have to.
because I have them. I have a barn and I've got them all in the barn. So I'd have to replace every single, I'm pretty certain I'd have to replace every single one of the actual light outlets, if you will, in order to make it work. So your simplification of it's not a big deal, it's not going to cost them anything. I'm sorry, that just is not true.
Again, ASAP has done savings analysis that incorporates the cost of materials and an electrician to come in and bypass the ballast in all cases, but that one we found that it saves consumers money.
It doesn't save consumers money when they have to replace their lighting fixtures, sir. Come on. I mean, it's a silly answer to say it's going to save you money, but first you got to spend all this money. Well, what if they don't have the money to do it to begin with because they can't buy the bulbs, right? So does the bill prevent you from buying the so-called fluorescent bulbs in other states? Are you prohibited from buying them and using them at your home if you buy them elsewhere outside of the state?
No, sir. It's only enforced at the point of sale.
Okay. So the point of sale, would that include buying them online and having them shipped to your house?
Yes, sir.
Meaning what?
Meaning the bill intends to regulate online sales as well.
You're going to regulate online sales. Got it. Thank you.
Comment I'll make is you, by your own testimony, you're saying it's cheaper, it's better, it's faster, where we can replace them. I'm questioning the need for the bill because in every circumstance, I've had to do some of this in my own home. And when I had the bad ballast, I replaced it with the LED. So I think people are doing that today. They recognize some of this, and I question where it's not viable. And I think in your testimony about the replacement of it, if you can't do it yourself, it does become expensive. And to assume that it's a cheap fix, if I have to replace 60 or 70 of them in my small business today, that's a major expense. And I don't know that there is a payback for that could be realized within years if you have to do it that way. But I think the market in general is fixing this problem. So I would ask that it's kind of an unnecessary bill to a point because people are moving in a direction. If you could show the free market that I can save money, that I can actually do this and I have to replace it anyway, I think that will fix itself. Isn't that so?
Thank you for your question. I don't see any other questions of this panel. No, apologize. We have a new system, so you can't, there's used to be a iPad here, but now you gotta catch them visibly and it's very difficult. So seeing no new questions, we'll move on to the next bill. I believe Delegate Johnson's still out, so we're gonna move on to House Bill 1182. Is there a Shawnette Walker?
Ms. Walker, yeah. Okay, sorry. Thank you, and good afternoon, Chairman Wilson, Vice and members of the Economic Matters Committee. My name is Shawnette Walker, and I am Chief of the Antitrust Division. And I have sitting behind me Gary Honig, who is Deputy Chief of the division. So the Antitrust Division is responsible for bringing law enforcement actions under the Maryland Antitrust Act. And when bringing these actions, these law enforcement actions under the Maryland Antitrust Act, the division seeks a number of remedies if our litigation is successful. And these remedies can be legal remedies like damages, or they can be equitable remedies like restitution / disgorgement, accounting, or injunction. So the equitable remedy. I'm sorry. Okay, I'm sorry. So again, like I was saying, the remedies that we seek could be legal remedies like damages, or they can be equitable remedies like restitution / disgorgement, accounting, injunction, etc. So these equitable remedies are determined by the court in the court's exercise of its equitable powers. So the equitable remedies that may be provided by the court are only provided when the legal remedies are deemed to be inadequate. So really the objective of the disgorgement equitable remedy here is to require that a person who profits from illegal or wrongful conduct, that they give up any profits made as a result of that illegal or wrongful conduct. So disgorgement essentially prevents the wrongdoer's unjust enrichment by recapturing the gains that they secured from the unlawful activity. Can I continue? I just got like, okay. Disgorgement ultimately just eliminates the possibility that the conscious wrongdoer will profit from their wrongdoing. So disgorgement is not a penalty and it's not damages. So HB 1182 merely seeks to clarify that the current statutory language, which says that the court shall determine whether a violation has been committed and enter any judgment or decree necessary to remove the effects of any violation and prevent the continuation or renewal of a violation in the future. And the statute goes on to say that the court may exercise all equitable powers necessary for this purpose, including but not limited to injunction, restitution, etc. So the way we understand this statute is that here restitution includes disgorgement. And HB 1182 would simply delineate explicitly that restitution in section 11-20983 includes disgorgement. And we think this is a uncontroversial amendment. The goal is just to clarify that wrongdoers should not profit from their wrongdoing. We can't imagine that anybody would object to that, saying that wrongdoers should profit from their wrongdoing. So with that, those are my prepared comments, and I'm able to or available to answer questions that the committee or the chair may have.
And seeing no questions, and while you can't imagine anybody would oppose this bill, is Bob Enton here? Come on up, sir. Thank you very much, ma'am. You're good.
I always thought you had a much bigger imagination, Mr. Chairman. Thank you. Members of the committee, Robert Etten on behalf of the Maryland Bankers Association, the American Property Casualty Insurers Association, and the Maryland Building Industry Association. We are in opposition to this bill. You know, it's a simple bill. It adds one word to the current law, disgorgement. What that means is that in addition to all the other remedies set forth in this section of the code, if you are the one that's been found to have violated the antitrust law, you have to just go back and disgorge whatever profits you may have made. So what are the current penalties? If you look at page 2 of the bill, what you'll see is that in lines 11 through 12, I'm sorry, 7 through 10, for each penalty, for each violation of the law, each day is a separate violation. There's a 4-day statute of limitations. I did the math at $10,000 a day for 365 days. Let's say that, you know, there's a 4-year statute. They could look back 4 years. They're talking about $514 million, about $14.6 million in penalties. That's under the current law. In addition, the bill provides, the current law provides for treble damages. And on top of that, the whole notion of disgorgement, I've done the research. There are only 2 states in the entire country that in their antitrust statutes provide for disgorgement. It's just an unlimited basic number that can go back many, many years. And we firmly believe that the current antitrust statute gives the Attorney General's office plenty of room to go after whoever they want to go after, collect huge fines, and keep them from doing what they're doing. So for those reasons, our clients are really concerned about this bill and would ask for an unfavorable.
Thank you, Dr. Enton. I just wanted to ask the question. So it's my understanding that this is basically individuals who have knowingly been found, you know, liable for violating our laws, and they in doing so they've earned money. And to my understanding, the disgorgement is like, well, you don't keep the money that you earned by bad, you know, by wrongful doings. Isn't that your understanding?
I think my point is basically, Mr. Chairman, that we think that that this is a wide open penalty with no limitations whatsoever.
But don't they have to prove? I mean, I'll step back just because we're both attorneys, sir. I would go with the fact that they would have to prove exactly how much money. Just with any other case, the burden is on them to prove that this was the amount of money earned with specificity. You're saying they just pick a number and the plaintiff or the defendant has to pay for it?
So if they take you to court, and the judge finds that you have violated the antitrust statute.
Yes, sir.
I believe that the judge then would have the discretion to impose a penalty that would require you to disgorge all of the profits that you've made. I don't think it says that the burden's on them, on the Attorney General's office, to prove to the court satisfaction that the profits were X. It's just, it's a penalty that may be imposed like any other penalty.
And I've always said, because I've never seen that before in my 20 some odd years of going to court, where it was just a sua sponte, give us all your money. But let's step that back. So you're saying the judge would just say the term all, and then it would just be left to the defendant to say, well, here's what I've earned? Or isn't there going to be some forensic examination of the books to determine just how much money? And I'm sure that's actually in the charging document. I mean, because the word all seems almost like a legal fallacy, because all is a very subjective statement. So in this case, even if the judge was to say the word all, somebody would have to find that bright line to say, well, all in this case meant this much money versus some other case where it meant much less or or much more. Would you not agree with me that courts are not going to be that loose with their findings or their holding, to do it with some specificity. Even if they were to say the word all, that they would then put the burden back on the AG's office to determine what all actually meant. Because the only other solution would then be say, we'll let the defendant decide what all is. Somebody's gonna have to figure out what all is. Either the judge, i.e. the courts, or the defendant, or the AG's office. And it sounds like, I feel like your argument's just a little specious by saying it's some unlimited amount, because somebody has to determine what that means. Would you not agree? In a court of law, they do move with specificity.
The only thing I can say, and I've never tried an antitrust case in my
Sure.
life.
I got you.
But I've spent a lot of time looking at this statute, reading the different cases that are out there about disgorgement. I didn't even know what disgorgement was till I saw the bill.
Got you.
Yeah, under the federal antitrust law, there's a case, a federal case, which ruled out disgorgement. The way I read it, once you have been found to have violated the antitrust statute, then the court, it's almost like they could impose a jail sentence. The court can sentence you to disgorging all of your profits. Now, I looked
Sir,
online, there are only two
sir,
states in the whole
you're-
country that do this.
You're extraordinarily correct. So I'll go ahead and put that in brackets. All of your profits then must be defined. If we want to roll with that, all your profits from your evil doings, you have to disgorge. And I'm saying, then if that's the case, then that must be defined by either the defendant, which I doubt, the AG's office, or the courts. Otherwise, we're dealing with a nebulous number that simply doesn't exist. Meaning it's not unlimited. I'm just trying to get you to understand. I don't understand your pushback, because we're basically admitting this is after you've been found liable of doing wrongdoing. So are you trying to, are you worried that there's going to be a commingling argument there? Because it doesn't really say that. It doesn't say because you put your bad earnings in with your good money that we're taking it all. They just, all the profits from this wrongdoing are all that they can get you to disgorge. I just want to make sure that you're not reading something that I don't see.
I think, they can, it just says they can require disgorgement. They can require restitution and engorgement, disgorgement. And there's no limits on it whatsoever. That's what they can do.
Right, but
So they could say you have to disgorge all of your profits.
yes,
They
all of,
could.
yes, and that's exactly what I believe the AG presented. If you get caught violating the law, then all of the profits from that violation, you will have to and could have to disgorge.
And I'm not sure how they're going to calculate that. My
But the
point,
burden
Mr.
would be on
Chairman,
the court.
is that the current code in Maryland has one of the strongest penalties that I saw in my research for violations of the antitrust law. They can fine you up to $10,000 per day for every day that you engaged in this activity, and they can order restitution to the aggrieved party. If you paid a fee or purchased a good, you get your money back. But this notion that you're now gonna, you're gonna be liable for whatever profits you may have earned, how are you gonna calculate that? Who's gonna calculate it? I don't know.
I
It's just pretty much unheard of, and you can't do it under the federal antitrust law.
Right. Again, we'll look at the federal law. I just thought it was a little confusing that you're basically saying that somebody who's unduly enriched because they have done something illegal should be allowed to keep those profits.
No. I'm
Or
saying the
because-
current penalties are sufficient,
Right, meaning
and
that
this
they,
is excessive.
which would mean that they should be able to keep their profits of their illegal
Yeah,
activity.
but their profits are going to be reduced, obviously, by the amount of the fine, by the amount of the restitution to the aggrieved party.
Well, we
It's
would
not
hope,
like they're just walk away with nothing, with no penalty. They can
no,
be fined millions of dollars a year
yes,
for
they
each
can.
year they did this.
Right, but we can agree that it's not fair for somebody to walk away with benefits from illegal activity,
I
right?
think that, Mr. Chairman, I think that if you violated the law
Uh-huh.
and you make the aggrieved party whole and you get assessed whatever fine or penalty up to millions of dollars that the court orders you to pay, this is just like another fine, if you will, on top of that. Under this bill, the money doesn't go to the aggrieved parties. The money goes to the state of Maryland.
Yes, it's taking out of the wrongdoer's pockets open. Thank you very much. I just want to make sure I got your argument as well as I could. And I understand. Thank you for the job that you do. Doug Howard, you look furious.
No, not at
Go
all.
ahead.
I'm just trying to walk through this thing, man. Like, so when do they take these profits? Just because they're doing wrong over here doesn't mean they're doing wrong over a few degrees left or right of that. So, you know, and there is going to be commingling of funds, I would imagine, to some degree. And when do they take these profits, and who decides up front? I mean, is this like a taking of profits and then it's sort of, well, defend yourself in court and we'll see what
I'm
we
not
give
sure.
you back?
Yeah. It's after you've been found guilty. It's not like, hey, in the meantime, give me all your money. This is not a highway robbery. This is as part of a penalty. They're going to say, you cannot keep any of the profits of your wrongdoing. If you earn this much, or you invested the money you got it wrongfully, and you made that much interest, give us all that. You should not be able to walk away with any profit of what you did wrong.
So it's all after it's been forensically
After it's been
looked at and
adjudicated. That's
Okay.
correct. That's why I said, well, I don't think it would just be a random, give me all your money, because if somebody says, give me all your money, I'm giving the $5 I'm going to tell them I have.
Right.
So,
Right.
you know, I may have a lot more. So I would assume that either the AG or the court would be like, no, you're going to give me exactly this much money, because this is the numbers we ran. Speak up now or give me that money. That's the way I've read the law.
I mean, that's.
Give me the money. Give me the money.
That's the way Tony Soprano does it.
There you
too.
go.
So yeah, there you
Get
go.
your money. But
I mean, I don't know if that's a great answer, but
thank you. Bob, great job. Appreciate it. I think we're done with this hearing. Do we have anybody here from Delegate Johnson's office? I apologize, young lady. I did not know. So we're going to go back to House Bill 824.
Can I call up my panel as well?
I'd like you to.
Mr. Chair, Vice Chair, and honorable members of the Economic Matters Committee, my name is Ria Patel. I'm Delegate Andre Johnson's Chief of Staff, here to introduce HB 824 on his behalf. House Bill H24 aims to streamline and modernize the processes outlined in the existing Maryland Self-Storage Act concerning auction sales of rental units that have been defaulted or been abandoned by tenants. Under current regulations, the law mandates that tenants must initial the rental agreement at the time of default or abandonment before the owner or operator of the self-storage business can proceed with advertising, either through newspaper publications, electronically, or on a website. However, this requirement poses practical challenges for businesses, especially when tenants cannot be located or the relationship between the tenant and owner is not good. The proposed amendment seeks to address this issue by requiring tenants to agree upfront upon entering and signing the self-storage rental agreement that in case of default, the owner or operator may advertise through newspaper, electronic, or website mediums. This upfront notification to tenants, as mandated by current law, must be presented in bold typeface. Additionally, the current law maintains unchanged provisions requiring the operator of the self-storage facility to contact and notify tenants of delinquencies and impending lien sales before any sale can occur. All other existing tenant protections and required notices remain in effect under the current legislation. My panel can describe the bill in more detail, and they'll be happy to answer any additional questions. Thank you.
Mr. Chairman, members of the committee, Bruce Periano, I'm here on behalf of the Maryland Self-Storage Association. I'd like to thank Delegate Johnson and his chief of staff who spoke for introducing and presenting this bill on behalf of my client. It's a very simple, basic bill. It passed second reader in the Senate today. Was not very controversial. The reality is that the current law requires, at the time the relationship has gone bad, it's a rental arrangement. When it's gone bad, either the tenant who stores the material owes money, or they've absconded, they've just left, they've taken in the middle of the night what they want out of the unit, and then they've left and abandoned everything else. They're hard to find. It's hard to locate them. The law requires that we have to do certain things, but what the law presently requires is that at that time where the relationship really is in bad shape, we have to get them to initial before we can advertise for a sale. Well, if we can't find them, and generally that's not the case because the relationship is not what it was when they initially rented the property, we can't go forward. And this business is all about renting unused space. I know you all know what self-storage rentals are, and we can't proceed under the current law. So we're trying to move that requirement up front. So when they come in and they sign the lease, renting the self-storage unit, they shall be told, the amendment that we're introducing to the bill is not may be advertised, but it shall be advertised in one of the three ways as the chief of staff for the delegate just indicated. And they have to sign it, and it's all in bold print under current law. So we're just moving it up front when there is a mature, good relationship so that it can act in a functioning fashion. Thank you very much. We urge a favorable report. Thank you.
Mr. Chairman, Mr. Vice Chair, members of the committee, thank you for the opportunity to testify today. My name is Daniel Bryant. I'm with the National Self-Storage Association based in Alexandria, Virginia, which also manages the Maryland Self-Storage Association. I ask for your support today for House Bill 824, a bill to modernize the advertising requirements in the Maryland Self-Storage Act. I wanted to walk through some of the elements of what this bill does today. First, current law does permit storage owners to advertise outside of the newspaper, but only if the tenant authorizes it in the rental agreement. This bill would allow storage owners to choose the method of advertising that they deem most appropriate, and customers would be informed of that in the rental agreement, which is contained in section 18-5034. Second, the bill in section 18-5043 would amend the required elements of what must be contained in every default notice to include the method and location of the advertisement. This change would apprise the tenant of the location of the advertisement at a relevant time following default, as opposed to making an election at the time of execution of the rental agreement. As you'll hear more from my colleagues today, the changes in House Bill 824 would make Maryland's law consistent with 30 other states that permit storage owners to choose online modern advertising or have no advertising requirement at all, like next door Virginia. Respectfully ask for your support for the bill. Thank you.
Mr. Chairman, and member of the committees, thank you for your time today. My name is Todd Snook. I'm the owner of Valley Storage Company. We have 58 locations in 8 states. As a lifelong resident of Maryland, I choose to operate here. I choose to headquarter my business here. My son was a page in this committee some years ago, and we bleed gold and black. So this is really a housekeeping issue for us. It is a hardship on both the operator as well as the customer. The customer has to pay through the auction fees, onerous newspaper fees because of the publishing requirements. There are no names listed in the newspaper ad. It's purely to get bidders. It is a hardship to the operator because in being in Hagerstown, we're only a few miles from 4 different states. So manager may be in Pennsylvania one day, Maryland another, and we have to know that we have to go through this extra step. We're in the business of renting units. This is an unfortunate byproduct of people not paying their bills, and we just really want to get our units back. And so I would urge support of 824. Thank you.
Mr. Chairman, Mr. Vice Chairman, members of the committee, thank you for the opportunity to testify today. My name is Jennifer Martinez. I'm the Vice President of Operations at Self Storage Plus. We operate 30 facilities in Maryland and 40 facilities across 5 other states. I ask for your support today for House Bill 824 to modernize the Maryland Storage Act. As a bit of background, our industry is not in the business of selling possessions of individuals or former customers. We are in the storage rental space business. However, sometimes sales are required when tenants do not pay rent to recoup the debt, and more importantly, return that unit back to inventory so that it may be rented again to a paying customer. The law requires that our rental agreements apprise tenants in bold type of the existence of our lien rights, and the property may be sold to satisfy the lien upon default. Additionally, the law requires direct notice to the tenant before the sale may proceed. In practice, local managers will attempt to contact the delinquent tenant multiple times before proceeding with the sale. through various forms of communication such as email, traditional mail, phone calls, and text messages. Resolving the non-payment issue in a way that does not require sale is always preferable in lien sales, but rarely brings in even 30% of the outstanding debt. After all attempts to contact the tenant and resolve payment dispute fail, Maryland law currently requires that the operator advertise the sale in newspaper of general circulation before conducting it, unless otherwise authorized by the tenant. The purpose of this advertisement is not to reach the tenant. That purpose has already been satisfied through direct notice. Current Maryland law does not even require the publication of the customer's name in the advertisement. Newspapers were once the most effective means to advertise upcoming sales and drive traffic to it. That is simply no longer the case. Alternatively, advertising online is much more effective at reaching the target audience of potential bidders, reducing the customer.
Thank you, Mr. Chairman. Just had a quick question, well, two questions, because I wanted to address the Office of Attorney General's comments, but Mr. Barriano, you have signed up favorable with amendments. Did you have an amendment or is that a mistake?
Yes, the amendment, if you look on the first page of the bill, line 21, we would take out the word may and the word shall,
Oh,
mandatory
okay.
would be added so that up front it would be mandatory for the company
Said that,
to notify and that they're advertising. And in the current law, it has to be in bold type. If you look in line 18, it has to be in bold type. So up front, when there's a good relationship, the rentor would know that if there is a default, they can advertise, but they have to be notified of that. So
Okay.
that I think strengthens the protections to the consumer.
Okay, so that doesn't get to the Office of Attorney General's concerns. So the Office of Attorney General's concerns, if I'm reading it, is that current law allows you to put a lien on 30 days after past due, and the idea that you put something online or a newspaper, they may not see it in that time frame. I think that's what they're getting to, that initialing it helps to make sure that person has received notice. And I'm just thinking about, because I do know a lot of people who use these storage places, especially like in the military, and they may be gone for a bit.
Yeah.
How do you know that they know that, something happened and they forgot to send that automatic payment in? How would you know that they got that message?
The current law does not require that they know that.
But the initialing kind of enforces that.
The initialing, you can't advertise the sale until they initial it. So they are generally gone. They've abandoned because they don't want to pay the rest, or they've taken their loved.
That's one type of person, but there are other types of persons who could not be.
So in the meantime, and I'm not being insensitive. So I don't think, and I say this very respectfully, I don't think the writer of the Attorney General's letter that they sent in or paper they sent really understand the functioning and the flow of this business. Really, these are business people that are very reputable. They even go beyond what the law requires in sending several certified mails. They make phone calls, they email and let the person know. But at the time this auction occurs, the relationship has gone south. They owe money, they can't pay anymore, and some of them just want to leave the material there as being abandoned. And we cannot, if we can't advertise and sell because we can't have their initials, that could be months, it could be a year. And it's just unrealistic business practices, because we are in the business of renting available empty space to people. So the amendment takes it up front so that in bold print, the person renting the self-storage unit knows that if there's a default, that the owner of the business has to, shall advertise it either in a newspaper or what have you. And respectfully, it's not necessary that they know about it because they can't be found. They've not answered the certified letters or the mails or the emails. And
But
we
that's,
need-
none of that is addressed in the way this is written. That's the concern that I have. And maybe I'm not seeing all the statute, but what we see is just that to me, you're not answering the spirit of the Office of Attorney General's letter. How do we know that they've been notified? And that's what we need to get to. We can talk about offline.
I'll be happy
Okay,
to, but
thanks.
as one of the witnesses indicate, they send out certified letters, they make phone calls, they do emails.
That may be the practice.
No, it's the practice of all of them, respectfully. It's, I'll be happy
And,
to.
off what Delegate Queen was saying, so because there is nothing, are you required to notify somebody? Right now, it sounds like you have to wait 30 days or you can sell off the property. Is that correct?
Yes,
And which to Delegate Queen's point, that may be a short amount of time, 30 days past due, correct?
yes,
All right, and I guess, are they required by law to send certified mail out to the last known address?
yes.
And how many days in advance of the sale are they required to do that?
Does anyone?
20 days.
Okay. And you're saying that, so let's say they haven't, and within 30 days and they don't respond, then what is your alternative?
What you want?
I can take
Go
that.
ahead.
So normal practice, which is also required by the lien statute, is to notify the customer either certificate of mailing or certified email. Certified email, with the advancements of technologies, we can actually confirm that the customer received that notification in their inbox, along with if they had opened it or not. With that technology coming back to our managers in the stores, they are able to then send out a certificate of mailing in addition to if either the email wasn't delivered or it wasn't opened.
So right now, once that certified email has been received and opened, then after 20 days, you can sell the property.
Technically, we can't sell until the customer is more than 2 months past due. So
Okay.
it's normally 61 plus days.
And then after 61 days, you can sell it. Now you're saying here that they need to initial something prior to you selling it?
The current law requires they have to physically initial the rental agreement before we can do that.
So upon entering the agreement, correct? We say physically enter the rental agreement. You talk about when I sign up for the rental property?
So in the rental agreement, it explicitly requires the customer to initial next to where we can legally advertise the auction.
Right, but right now you can't do that.
If an old rental agreement did not have that explicitly stated on that rental agreement when that relationship started, we have to solicit a signature from that customer at the time the account has gone into lien.
And if you don't get the account, then what?
We can't do anything.
I mean, so to be clear, so you're saying that if you cannot get a signature, then
We can't advertise.
you cannot advertise.
I'm sorry, I didn't mean to.
You can sell that, correct?
We have to then take additional steps to advertise the sale in the newspaper and everywhere that.
Correct.
We
And
can.
I guess that's what I'm trying to get to right now. You're not stuck with the property. You can still sell it, correct?
Yes,
It's just
takes
additional steps. And how much longer would you say it takes, ma'am?
It could take up to another 15 to 20 days to.
Right.
Yes.
And I think that gets to Delegate Queen's point about what's the rush if it's just another 15 to 20 days?
But adds another month's rent onto that customer's debt. That would reduce the amount that we can recover, and it increases the amount that the customer still owes us. So we're just trying to expedite the process to reduce the debt in which the customer would continue to owe.
Compared to the value of what's in the actual.
Correct.
All right.
And this is all after, Mr. Chairman, the 60 days of waiting.
Mhm.
So you please include that as well.
No, I
That
understand.
we're stymied
Right.
there.
And I guess, we're concerned with the delegate was concerned with somebody being deployed. And I know I was in the military, I was deployed all the time. In addition, and believe me, yeah, you don't always get to answer your emails or not. The same with somebody else opening up your mail. I guess, or you're hospitalized for extended periods of time. I was just a little concerned that, not so much with you being able to finally, dispose of the property as you see fit, but the timeline that was drawn out and, is that enough time for people to get what maybe everything that they own? And I think that's what I think people may be a little concerned with is, being in that rush, because I understand you're talking about the money that they owe you versus the money, but I don't think that's the concern here. I don't think people are concerned with the debt. They're concerned with people losing property. Let's admit, they can never get that back. They can argue with you about how much it was worth, something wasn't done correctly, but they are still really stuck with that loss. It's like selling some of these photos. You're not gonna get those photos back no matter what how much money you give them. So, but I mean, I think we have enough, for the committee. I appreciate everybody's, testimony. I think we've gotten everybody correct. I just want to make sure we haven't missed anyone.
Yes, you have.
Thank you. So, I don't see any further questions, so we'll move on to our next panel. Thank you very
Thank
much,
you.
guys. All right, actually, I believe that completes this bill
I
hearing.
believe it does.
Thank you very much.
Thank you.
Gonna move to House Bill 996.
All right, good afternoon, Chair Wilson, Vice Chair Crosby, and members of the House Economic Matters Committee. Thank you for the opportunity to present HB 996 for your consideration. For the record, I am Delegate Jennifer White Holland. Simply put, HB 996 would change the name of the Consumer Council to the Consumer Protection Commission in the Division of Consumer Protection in the Office of the Attorney General. As such, the 9 members who are appointed to serve would be considered commissioners. The Consumer Council is responsible for advising the Division of Consumer Protection and serves as a voice for consumers, businesses, and the greater public. The request to change the name was discussed at previous Consumer Council meetings. As such, the Council and the Office of the Attorney General is aware and in support of the name change. Given the important work that they do, changing the name will better enable them to communicate, educate, and engage Marylanders about the work they do and be seen as a resource. Prior to the hearing, I consulted with the Office of the Attorney General early in the process and submitted sponsor amendments that address their concerns that simply change the name of the bill, as well as ensuring that the per diem compensation is struck from the bill. So everything has been worked out. And given this, I respectfully request a favorable report for HB 996. Thank you for your consideration. I'll now turn it over to Ms. Linda Dorsey Walker, who was a part of my panel.
Good afternoon. Chairman Wilson, Vice Chair Crosby, and members of the Economic Matters Committee, thank you for the opportunity to submit testimony on support of House Bill 996. My name is Linda Dorsey Walker. I've been a member of the Consumer Council since 2020. This legislation will change the name of the Consumer Council to the Consumer Protection Commission. What is the Consumer Council? Why does it exist, and why do we seek this change? What if I were to tell you that the Consumer Council was established 50 years ago to study, track, measure, and control consumerism, which is the level of consumption in the United States? Consumer Council members are people with special backgrounds in logistics, consumption, and supply chain management. Sounds good, right? However, that is not the work of Maryland's Consumer Council. You see, the problem is that the average Marylander has no idea what the Consumer Council means or does. Now, in its 50th year under the Office of the Attorney General, the Consumer Council lacks an identity because our name is very nondescript. Once we state that we are an advisory council to the Consumer Protection Division of the AG's office, then most people have some notion of what we do relative to consumers. The Consumer Council is a body of 9 citizens appointed to serve not 4 years, but 6 years on a council charged with providing oversight, advice, and advocacy for the Attorney General's Consumer Protection Division. Thousands of citizens contact the Consumer Protection Division each year with grievances. They understand the Consumer Protection Division allows consumers who believe their rights have been violated an outlet for filing a complaint, launching an investigation when it's appropriate, and seek legal and sometimes monetary remedy. Hence, we Consumer Council members want our name to echo the name of the well-understood Consumer Council Division, which we advise. We urge your favorable report with amendment.
Make sure there are no questions. Thank you for this daring and edgy bill.
Thank you.
I believe that's all we have for this bill and this panel. Thank you very much, ma'am.
Thank you,
Mr.
Mr. Chair. Thank you.
Moving on to Delegate Stewart here. He is. Come on up, buddy.
Which one, Mr. Chair? Add two. Which one you mean?
You are the delegate. 11:56. I just 11:56.
So I think the chairman's being modest. He's been begging me all session, like, when are you coming back to ECM? I've been missing you, and the day is finally here.
We're all missing you. I think Mark is he's got some questions he's been working on all week. So
yeah,
we're looking forward to these.
I see him over there. I see him. He's excited. All right, Mr. Chair, Mr. Vice Chair, members of the Economic Matters Committee. For the record, I'm Delegate Vaughn Stewart. This is House Bill 1156. This bill and then the next bill that we're going to talk about both are attempts to take a crack at the same problem, which is that too many Marylanders are being victimized by scams. And this is especially prevalent in our senior community. This bill is about wire transfers. The next bill you're going to hear about is about gift cards, but both are a huge and emerging problem. Now, the reason that scammers target wire transfers in particular to try to come at Marylanders for is because, bizarrely, consumer wire transfers are exempted from a federal law called the Electronic Funds Transfer Act. In all its wisdom, in the 70s, Congress passes this federal law about electronic funds transfers. This is a new and emerging area in banking, and they want to make it clear that we're not going to allow fraud to take place. And they name basically every other type of electronic transaction you can think of. Debit card payments, withdrawals, transfers, but they don't include consumer wire transfers, partially because at the time you couldn't do them electronically. To do a wire transfer back in the day, some of the people may remember, I don't, but to do it back in the day, you had to actually go in person to a bank branch, and now that's changed. So that's led to a very strange status quo, where for every other type of electronic funds transfer, it's under federal law where you have these consumer protections. Now, what are the consumer protections? It basically says if you notify your bank quickly that an unauthorized transfer has occurred. And so not like, you getting scammed by an email and you make the transfer yourself. If someone else hits send on the transfer, then it's unauthorized, right? So just for unauthorized transfers under federal law for every other type of transaction, your damages are capped at $50 if you let the bank know within 2 days. And if you let the bank know within 60 days, your damages are capped at $500. And so because you're putting the burden of the loss on the bank, they have all these security measures in place to make sure people don't get scammed. But consumer wire transfers are cut out, and that's why scammers are flocking to that type of transaction. Banks don't have to be as safe, and so sadly, sometimes they're not. So I want to, with that out of the way, I just want to touch on a little bit about what the opponents are going to talk about. First, they're going to say this is confusing. I actually think it's much more confusing that we carve out one type of transfer from every other type. So right now in Maryland, this is crazy. If you send a consumer wire transfer out of the country internationally to a friend you got in Canada or Brazil or France, I know that I think Delegate Fisher has a lot of friends in France in particular. If you send a remittance transfer out of the country, you're within the gambit of federal law and you're subject to all these consumer protections. But if you send a consumer wire transfer to Indiana or New Mexico or Massachusetts, you're not. You're on your own. You're subject to the state's uniform commercial code. So we're trying to plug this loophole. And I know one other thing, the opponents are going to say this is costly. Well, this doesn't cost financial institutions anything to do or any extra burden unless they were already being so lax in this area because the burden wasn't on them. Yeah, it is true that maybe it'll be a little bit costly to prevent fraud if they weren't doing anything before. But they're already applying these rules to every single other type of electronic funds transfer. We want to protect the seniors of Maryland. We want to protect all consumers of Maryland from being victimized by preventable unauthorized transfers. And we think plugging this loophole will make a meaningful difference. I was just going to urge a favor report. I'll make one other thing that the opponents are going to say. This applies to all financial institutions that operate in Maryland, just like the UCC does. We're not singling out Maryland state charter banks. I'm not trying to pick on Maryland banks. I want everybody to be treated differently. So the big guys and the little guys are going to be under the ambit of this bill, just like they are under the Uniform Commercial Code. I urge a favorable report.
Good afternoon, Mr. Chairman and members of the committee. My name is Pat McNichol, and I'm an attorney at Kelly Guzzo PLC, a law firm devoted to consumer issues in Maryland, Virginia, and Washington, D.C. My work pertains exclusively to matters of consumer law, and within that field, I've developed a niche litigating matters of unauthorized transactions, including wire transfers. House Bill 1156 is necessary because the current legal landscape provides consumers with little to no recourse in the face of wire transfer fraud. For no reason that makes sense in the modern age of electronic banking, unauthorized wire transfers are treated differently than any other kind of unauthorized electronic funds transfer. The upshot is that consumer rights differ depending on the mode of transfer chosen by the fraudster. With reason, my clients are often baffled when I tell them that they have or don't have a good case based on what type of transfer the bad guy chose. Of particular concern regarding wire transfers, once the money is gone, it's gone. Sometimes banks try to claw it back, but the bank that receives the funds has no liability to anybody except for their own consumer, so they'll never give the money back. Even when the transfer is caused by no fault of the consumer, financial institutions almost invariably hide behind Article 4A of the Uniform Commercial Code to deny relief. The most common response they give consumers is that the transfer was valid because it was made using the customer's name and password. In other words, financial institutions admit that the transactions were unauthorized, but they deny relief because they think they can under the law, or more likely because they know litigation is not likely under the remedies that current law provides. To be sure, even when consumers have potential recourse under Article 4A, financial institutions know that consumers either one, will not be able to find an attorney to take their case, or two, will not have the resources to fight it to the extent the financial institutions come. I even had a case recently where the financial institution said to me, and this is a large national bank, they said, even if your client wins all the money back, they're going to spend more money on attorney's fees and even the cost to litigate the case, including hire an expert, and it's just not going to be worth it. So we think that House Bill 1156 is necessary to give consumers the remedies that are available under the Electronic Fund Transfer Act. Thank you.
Good afternoon, Chairman Wilson, Vice Chairman Crosby, members of the what is the name of this committee? Economic Matters Committee. My name is Karen Morgan. I'm a member of the Executive Council for AARP Maryland, and I'm here to testify today in favor of House Bill 1156. We are in support of this bill because this bill points up a very critical question. What is an authorized transfer? Because scammers are so adept at tricking people, and banks say, well, you know, you said it was okay, so we're not gonna refund the money because you said it was okay. But consumers are under an onslaught of tricks, deception, all kinds of things. And here's the situation that I think of when you buy a house. I don't do wire transfers normally, but when I was the executor for my mom's estate, I needed to initiate a wire transfer to arrange for the selling of her house. And my heart was in my mouth on settlement day because that was the remainder of her estate that was going to go to the rest of my family. If something went wrong, there was no way that we were going to recover that money. And so I was quite scared when I got the call from the settlement agent saying that there was something wrong and that the wire transfer did not go through. Now, in my case, it wasn't a fraudulent situation, but what about when it is? consumers have no idea if a title agent's email's been hacked, if a customer agent or somebody in a settlement agent's office has clicked on okay, let me download this link, or let me download this file that could be fraudulent. They don't know whether these scammers have inserted themselves into the chain of communication. So that's why we think something needs to be done. The law needs to change to provide protections, and that's why we are asking for a favorable report on House Bill 1156. Thank you.
Good afternoon, Chair, Vice Chair, members of the committee. My name is Marceline White. I'm the Executive Director of Economic Action Maryland. I'm here in strong support of House Bill 1156. Our SOAR program, Securing Older Adult Resources, works with older adults. We returned more than $1 million to over 900 older adults in 2023 and provided consumer education, scam prevention, digital privacy, and financial education to 458 older adults last year. It was important because nationally, Americans 60 and older lost $3.1 billion to cyber fraud in 2022. And that was an 84% increase from 2021, according to the FBI. So this bill is needed because cyber fraud is increasing. In Maryland, the clients we work with have told us story after story about fraud, from grandparent fraud to more sophisticated tech support scams. There was a recent story in the newspaper about a retired civil servant, a former attorney in Montgomery County, who was defrauded out of $661,000 from a wire fraud transfer. This bill is needed to protect older adults like that civil servant. This builds on our past legislative history, working with banks and working with the General Assembly to protect older adults, and extending the protections that are already found in the UCC, Maryland's UCC, and extending these and taking the part of the EFT and incorporating them into the Maryland UCC. We think this builds on the protections and that it is timely and needed, so that victims of financial fraud will be able to seek justice and get the protections they need going forward. For all these reasons, we support HB 1156 and ask for a favorable report.
Thank you, Mr. Chair. So first, Karen, thanks again for coming in. I appreciate it. I know you're a fiscal note writer, right? So
Correct. Guilty. Yes.
yeah. So no, just wanted to thank you anytime I get a chance to. I guess two things. One, does this only apply to state banks, or would it apply across the board?
Across the board. I know
Okay.
that the opposition testimony, I think, got a little bit confused on this point. We're not trying to target, Maryland State Bank specifically. If you look at the UCC, that applies to everybody doing business in Maryland. We want this to apply across the board. In fact, we think probably the Maryland State Banks are good actors in this space. It's the big guys, I think, who are a little bit weaker on this.
Yeah, so I will then give you an example, and maybe you can kind of talk me through it, of what just happened recently to a constituent and somebody I work with, right? They got targeted online. It's her mom who's in her 70s. They ended up doing 3 separate wires for I think a total of $340,000. Significant chunk of money. They went into one bank. Well, I'll just use it. Bank of America. They go into Bank of America at one branch. That teller denied it. Denied making the wire because they suspected it was fraud. They then drove to a different Bank of America, and that next teller processed the wire, not suspecting or didn't suspect any type of fraud. How would this bill, or does this bill specifically pertain to something of that nature? Because that problem still hasn't been rectified. And here I am, with a constituent, somebody I care about, is out a significant portion of their life savings.
Thank you for that question, Mr. Vice Chair. First, I just want to say my heart absolutely goes out. We're hearing these stories all the time. As y'all know, I represent Leisure World, and a number of my constituents have come to me with this problem, which is why we're putting this bill in. If it's okay with you and the chair, I'm going to defer to Mr. McNichol, who is kind of really one of the nation's leading experts on this, to answer your question, though.
Thank you, Delegate Stewart. The short answer to your question is in that circumstance, those transfers would not be considered unauthorized under the law, under both the Electronic Fund Transfer Act and under the proposed House Bill 1156. That would likely be considered an authorized transaction. There may be avenues for liability. Banks do have an obligation under Maryland law to report suspected elder exploitation under Financial Institutions Code, Section 1-306. So there may be an avenue for her to get relief through that. But this would not, this governs unauthorized transactions, as Delegate Stewart pointed out, when the fraudster is the person who actually sends the money.
Yeah. Yeah. In other words, you know, if you get an email that's saying, hey, I'm your grandkid or whatever, you know, and then you're the one who actually takes it out. Unfortunately, you do have other remedies, but not under this bill. Yeah. Thanks.
Thank you, Mr. Chairman. So I think this is certainly an interesting protection we would want to have. I'm more concerned about can we do it? I'm more looking at the Maryland State Bar Association's letter where they talk about, you know, elder financial exploitation legislation that other states have, but that it's not part of the Uniform Commercial Code. And so, I mean, I understand what you mentioned, Delegate. I think this was something that was missed federally, and maybe we need to make sure we talk to our federal representatives to change that. But I don't know how we could enforce this. And you're saying you want it to be for national banks as well as state banks. I mean, I don't know where we have in statute where we can say something that applies to a national bank. And if this is right, what the Maryland State Bar Association is saying, this hasn't been done any place else. So I don't know that we can do this, but, you know.
Yeah, all really good questions. And I appreciate you raising the letter from the Maryland State Bar. I want to reach out to their business law section to talk through. I think their letter is a little bit confused on some of these points. I'm not sure they totally understand what we're trying to do here. They are correct about one thing, and you are correct about one thing, which is that we would be the first state to do this. That's true. And there are other types of things that other states are trying to do. The reason that we have chosen to try to lead the nation on this and to try to make Maryland, honestly, a more attractive state for seniors because they feel like they're at least a little bit more safe from fraud is because every other type of transfer, every other type of electronic transfer is covered. And so no, it's true. It's true. But there have been other types of example in Maryland where the federal government did mess something up and we stepped into that void. We absolutely have the legal authority to govern the rules of federally chartered banks. If they want to operate in Maryland, we can tell them what to do. And in terms of enforcement, both the state AG's office and private plaintiffs, if they lost money due to an unauthorized transfer, and the bank did not follow these rules, whether it was the federal law or the state law that we're inserting into the UCC, they would be liable. We've talked to the, you know, National Consumer Law Center and a bunch of different people about the thorny preemption issues here. They're pretty interesting, but I will. I appreciate that.
I believe that's all the questions we have for this panel. We're talking about, I think, getting preventing elder fraud prevention. So in opposition, we have Bob Benton and Jason Weintraub. Jason, you're back there. Come on up.
Good. Mr. Brennan is back.
You sure? You don't want to talk about how to not do this bill?
We're good.
Thank you.
Thank you, Mr. Chairman, members of the committee, Robert Enton on behalf of the Maryland Bankers Association. And the sponsor and I did talk about this bill before it was introduced. Delegate Queen is very right. If you look at the fiscal note says that the Office of Financial Regulation notes that the bill may place Maryland charter depository institutions at a competitive disadvantage of other state and national banks, as those institutions would not be subject to the bill's requirements. Now, the reality is that our large banks in your districts are the large banks that have multiple branches in multiple states or national banks. They are not regulated at the state level. They cannot be regulated at the state level. There's a federal preemption. Your smaller banks in your communities, like in Baltimore City Harbor Bank, for example, that is a state chartered bank. In Montgomery County, Sandy Spring Bank is a state chartered bank. Right. But this bill would only impact our state chartered banks. That's the reality of it. Number two, I would say to you that this is in a change to what we know as a uniform law. And this is something that has not been even considered in any other state in the country. And it's not something that's gone to the National Conference of Commissioners on Uniform Laws, which is what the current law came out of. So I think it's just premature at this point that we would, delve in here and pass this legislation without, trying to see what's going to happen. And maybe it gets addressed at the federal level, or maybe the Commissioners on Uniform Laws want to address it. But there's been no work whatsoever on this, and it is a major change in Maryland law for your state chartered small community banks, and that's why we're opposed. Thank you.
Moving on to the next bill. Delegate Stewart, 896, another bill, retail sales of gift cards Scam Prevention Act of 2024. You name your own bills, I take it.
Delegate Fisher told me he likes when I have short titles on them. It helps him understand what it's about. So I don't know. I'm just trying to
Oh, my God.
I'm just trying to kowtow to the committee a little bit. I'm just trying to get a favorable reception.
Oh, Lord.
All right. For the record, Mr. Chair, Mr. Vice Chair, members of the committee, I'm Delegate Von Stewart. This is House Bill 896. So this bill, the previous bill is about wire transfers. This bill is about gift card scams. The traditional gift card scams that you probably have heard about is someone emails you some fake thing like, hey, I'm actually your grandson, or they call you, or they say, hey, I'm in jail. I need you to go buy this gift card. Send me the number, etc. That's still happening, and that problem is rising. But in the last year, we've seen the advent and really the rise of a new type of gift card scam called gift card draining. And this involves, you can Google it, this involves basically someone going to a store and collecting the digits off of a gift card in the store, using some software to steal the money while they're still in the store, and then placing it back on the shelf. And so we've seen a rise of people who basically think they're buying a gift card, they take it home, and they realize there's no actual money on it, and they have no recourse to do anything about it. So this bill is trying to fix both of these problems, and it has been the topic of hours and hours of negotiation. Now, I've mostly skated by. I've mostly avoided having to do any of tough work here. It's mostly been Kaylee to my left, and also Senator Kramer, the cross file, that have spent hours and hours talking to all the different stakeholders on this bill to try to figure out how we can come up with a compromised product here. And so we've gotten, of the three manufacturers of gift cards, we've gotten two of them at the table. The retailers are at the table. Everybody's at the table. I think we're going to have a kumbaya moment before we're done. But I'm going to walk through what the bill does. Number one, it requires sellers of gift cards to train their employees about gift card scams. A lot of people are already doing this. A number of states have already passed this rule. Number two, it requires sellers of gift cards to post signage around their gift card booth, their little area where they sell gift cards in the store, about the possibility of fraud. Again, a lot already do it. I actually have a great example from the Safeway around the corner from my house of their sign. A number of states have passed that as well. Number three, and the most controversial, is we have some new packaging rules for gift cards. And Kaylee's going to talk a little bit more about this, but we've bifurcated it with some sponsor amendments into the two different types of gift cards. One is called an open loop gift card, which is like, and actually I have some examples. By the way, Senator Kramer purchased these. I didn't. I would pass them around, but I think maybe Delegate Fisher would steal them and then my senator would get really mad at me. But they have real money on them. So this is a Visa vanilla gift card. This is called basically an open loop gift card. These are the ones that the scammers love because they're basically cash. Then you have examples like eBay, and you have like Lowe's, and you have Target. These are closed loop gift cards, meaning they're only good for one store. And the scammers don't like that as much because they don't necessarily want to go shop at eBay. They just want the cash. So what the scammers do is they'll go drain the cards, or they'll steal a card, or they'll somehow get a card from someone. And a lot of times they just use the cash. Sometimes they go on reseller marketplaces. There's one called Gift Card Granny that is very popular. You can Google it. And it's almost like a pawn shop potentially for stolen goods. Just like a pawn shops are usually selling totally above board goods, but sometimes they get duped into helping out selling stolen goods. Similarly, the online reseller marketplaces for gift cards, unfortunately, sometimes are entangled in this whole fraud scheme. So not only are we requiring manufacturers to do better packaging, these are some of the bad examples. So this one just straight up has the authorization code on the card itself. I don't know if you can see it. This one from eBay is actually the gold standard. I don't know if y'all can see this, but there's something called a rip strip that actually the cashier, when I bought this card, they ripped it off. And previously you couldn't see anything. What's also really nice about this eBay card is that it warns the cashier not to sell a card that's been tampered with. And it warns the consumers about the prevalence of gift card scams. So eBay really deserves kudos, but we don't even have some of the worst situations. Y'all have probably seen some of the ones that are basically just like minimally glued to the card is just minimally glued to a backing. That makes it super easy to just rip the number and move on with your day. So number 4 goes back to this reseller, goes back to Gift Card Granny. We're going to make Gift Card Granny just as Georgia does, and just as there's a federal bill in some other states that do this. We're going to make Gift Card Granny do some very basic things. Number 1, if you're an online reseller of gift cards, you need to keep a record of your consumers. You need to keep a record for at least 3 years of who you've bought and sold gift cards with. And number 2, if you're Gift Card Granny and law enforcement calls you because a retailer has called the cops and said, hey, we've had this massive theft of gift cards, you've got to hand over your books to law enforcement so they can investigate the fraud. And then finally, the last thing that's in the bill is just the effective date. We've worked with all the stakeholders to push that back a little bit. And we've made a difference in the bill between, again, the closed loop, which scammers don't really use. So we're saying that we're going to push that back a little bit. And the open loop, which is what the scammers are using, we want that effective date to be bumped up as soon as possible. But with the understanding that a lot of these retailers have already made bulk purchases, like through, for example, the holidays. So pushing back the effective date just makes it a little bit more feasible for these folks to comply. But overall, what you have, I think, before you, Mr. Chair, is something where 99% of the people, I think, are going to be on board with this bill. This is going to be a nation-leading bill, but we're going to finally take a swing at this problem that's victimizing way too many of our friends, our constituents, and our neighbors. And I urge a favorable report.
Well, much like your cross-file, we appreciate your economy of words. You like to go next?
Okay, sure. Good afternoon, Chairman Wilson, Vice Chairman Crosby, members of the Economic Matters Committee. For the record, my name is Karen Morgan. I'm a volunteer advocate with AARP Maryland, a member of the Executive Council, and we're here today to support House Bill 896. AARP did a national survey a couple of years ago, and one of the things that came out of that survey was that 9 out of 10, it was a national survey, but 9 out of 10 people surveyed said that lawmakers need to do more to protect people against gift card fraud. And over 60% of those people strongly agreed that lawmakers need to do more. It is dangerous for some reason. It is dangerous out there for consumers these days. You can't go to the bank. You can't buy something online. You can't go into a store. You can barely have a conversation without running into fraud. And gift cards are supposed to be for gifts. That's something that my mother forgot when she got a call about her grandson being in trouble. And the first thing she went to do was to get gift cards. And it was only after purchasing several gift cards that she contacted my brother, who let her know that my nephew, her grandson, was just fine. Scammers love these gift cards because they are virtually untraceable, because they can be easily converted into Bitcoin, which is really untraceable. And we need more protections. Merchants need to step up and help consumers stay safe in this crazy fraud-induced world. That's why we're in favor of House Bill 896. Thank you.
Good afternoon, Mr. Chair, Mr. Vice Chair, honorable members of the House Economic Matters Committee. For the record, Kaylee Locklear here on behalf of the Maryland Retailers Alliance. I realize this is a little bit odd because I am signed up favorable with amendments. Nevertheless, I am here on this sponsor panel. And the delegate is not kidding when we talk about the amount of time that we have put into this issue. Just for a little context here, about 1.5 billion gift cards are produced in the United States every year. So we're talking about massively impacting this industry. And we've come to the table on a lot of these matters. I think what you're going to hear the most amount of discussion with and the largest amount of concerns. And I'm not sure if you have the amendments in front of you. We were working with the amendments office last night, 9-10 p.m. to try to get them to you. And there are quite a few, but the one area that we're really going to have a lot of conversation around is this packaging issue. I think that we've come to agreements on everything else, from online third-party registration to training to signage to what appears online to warn consumers. Sell-through dates we've agreed on too, exemptions for mom and pops, and penalties, which is, quite impressive. But the packaging is where we're really getting into it. And so you have an organization called Blackhawk. You have SVS, who is behind me, who's going to talk about the amendments that they proffered there. But it still allows for flexibility for the industry. So we really had to thread the needle very carefully here. Obviously, technology is rapidly advancing, but at the same time wanted to conceal as much information needed on a gift card for both activation and redemption. This is a lot. I'm glad to answer any questions. I couldn't cover a lot in my 2 minutes, so I'm glad to answer any questions you all have.
Kaylee, I have a brief question. So
Yes,
right
sir.
now, currently, if I go to one of your clients here and I purchase a gift card that's already been drained, isn't the retailer responsible for refunding me my money?
So it actually would not already be drained. So somebody has gone into that store probably. There's like 15 different scams going on here. So let me just focus on one.
I'm just saying, how about this?
Yep.
I buy a card, it's not worth the value that I bought it for.
Well, it is when you buy it, but it's probably the second you walk out, it's drained off of the card is what's
And it's done because
confusing.
somebody knows I've walked out?
So we don't know. Yeah. So somebody went in and they took the information off of the card and tied it to an account. Somebody walks in, you put $50 on a gift card to wherever. You walk out of the store thinking that $50 is on the card, and that person is constantly pinging, that scammer is pinging that card to transfer the money. But they sit there and wait for you to put the money on the card. It's not like automatically drained or preloaded.
Gotcha.
They're waiting for you.
So it's not basically the retailer, which will get to my second question, because that was my understanding as well. Is it the retailer, then it's basically the packaging that makes the biggest difference as far as protecting the purchaser, because if they don't have access to the information, they can't ping it. They can't do anything to set it up ahead of time, correct?
Packaging is a huge part of this equation here. Listen, we can train our employees to the nines. We can
Correct.
put signs up everywhere,
Right.
but packaging has got to be a part of this equation.
Got you. Okay, I just wanted to make sure. Thank you.
I'm back.
Right.
I had to go represent.
All right.
I represented well at HGO. Thank you. So I've watched, I've watched series about this issue nationwide. My question would be, I like the idea of like putting the restrictions on the packaging, but in the meantime, why can't we just make it that it's not accessible to patrons, period? The same way that, unfortunately, some of the grocery stores in my community, you can't even get infant milk without asking someone to go get it for you. You can't go get deodorant without asking someone to get it for you. So why can't we just put these items into a glass container for the time being, get to the point where but why do we have to, because going back and asking the manufacturer to change it all is going to take a longer time, and the scams are going to go crazy between now and then.
Two things here. So it puts the onus entirely on the retailers when it's the product itself that has the problem. And also, as much as everybody loves us locking things away and finding somebody to go ahead and open that lock case, like that's another problem here. But if we didn't write it this way, then there would have been no incentive for manufacturers to actually change their products and change security protocol, right? So even though those products are locked up, you would have just put the onus on retail and nothing would have changed.
I think his point, well, what I took from the point was that we agree with you, but we also agree that in the meantime, because there are dates certain that this has to be done by, and pushback from the manufacturer why wouldn't it be healthier for them to, for Target to pull it back to behind the counter or someplace where you had to ask for it? Or, in certain areas, I think Costco is an example. You'll grab something. It's not a card, but it's something that they scan and then they hand you out of their drawer a actual card that's actually in a drawer. Meaning what you see out there has zero value. It's just, I want a $50 gift card from Vanilla, whatever that means. I'm sure you know, but basically only upon me paying for it do they then pull one out of the drawer, because it's the same as cash. Or if it's blank, when they load it on, you understand, where they have zero access to any of those numbers. If those are all on the register because they are like money, then I think in the meantime, we would get from point A to point B without more people being robbed or bilked. That's what I understood the good delegate's question to be.
So I think, I understand what you're saying. So temporarily, theoretically, we could just lock them away, put them behind the counter. That was actually, I think the senator and the delegate's initial idea here, but they wanted to.
Did they back down? They backed down from you? Nice.
We looked at it comprehensively and looking at the solution as a whole and what we needed to do here.
Yeah, the original bill would have said, well, essentially would have let the manufacturer off the hook, but it would have said, okay, well, if the manufacturer can comply, you can sell it out in the open space. But if the manufacturer can't comply, you've got to lock it away behind. That was the original idea. But one thing that, Kaylee's not going to mention because she represents these people is sometimes the employees themselves are the problem. And if you have it behind a locked container, even for a short period of time, that doesn't solve the problem when Joe, the employee, is passing the cards to be drained to his buddy Leroy. Whereas the packaging would solve that problem as well.
Well, I don't really appreciate the Leroy thing, but I do understand your point. I'll say that I
grew up with a lot of Leroys in Alabama,
Mr.
Chair. Yeah.
But I'll say that but I do believe that there's a methodology, because again, at the end of the day, what the delegate said, it makes sense, because I'm concerned that we go down this path and then the manufacturers are delaying, or they're not able to do it, or they're for whatever reason, versus it sounded like a very obvious solution would be having this taken care of. Are you okay, sir?
No, I don't think so.
I think he's tying his shoe. So, but again, I appreciate that. But because I say this in all fairness, that once the bill is left, once you testified, it does become our bill and our solutions to make sure we do as best we can do for the individuals. You guys identify a problem, possible solutions, and then we come back together to try to figure out what we feel as a body is the best solution. So thank you very much.
Amen, Mr. Chair. That's right.
Thank you, sir. I don't believe there are any other questions.
Yes, sir.
Dave, go ahead.
Thank you, Mr. Chairman. So just to be explicitly clear, essentially what the bill, what you want the bill to do is take the packaging and cover up any ID numbers or activation numbers or anything like that, just to ensure that if somebody grabs it, they can't grab anything off of it. So you want the industry to basically repackage them moving forward, just to ensure that somebody can't grab it off, take a photo, do whatever. You're looking at ID numbers, PIN numbers, all of that stuff.
That's true for the open loop card. We're going to be a little bit more flexible in the manufacturing on the closed loop card because they're just not used for scams as much. But you're correct that we want the industry, to the extent feasible, to cover up any numbers on the open loop cards. And I know this is possible because the same manufacturer made both of these cards. So the eBay really strong card with the rip strip was made by the same company, their representatives are behind me, as the card that has all the numbers. So this is not a feasibility issue. The manufacturers not only can do it, they're doing it. That company made this really good card. Yeah, sorry.
So delegate, then I would think it would be in their best interest to do this. Why are they fighting, or are they fighting? Are we going to come up and have some unfavorables or favorables with amendments on it?
I think we are. So I'll let them speak for yourself. But what I would say is a lot of industry has been moving in this direction because they keep getting sued. There's so many lawsuits in this area because it's an obvious negligence claim to say, if you're putting this out there with the authorization code or the redemption code wide open, that's on you.
Well, I'll ask them why they would.
Yeah, that'd be good.
Thank you.
That'd be good. Thank you.
Seeing no further questions of this panel, thank you. Steve Sakamoto-Wingo, are you here for information or to testify, sir? Outstanding. Thank you very much.
Good afternoon, Mr. Chairman, Mr. Vice Chairman, members of the committee. Steve Sakamoto-Wingo here on behalf of the Consumer Protection Division, the Attorney General's Office. We're here in support of House Bill 896 with one amendment. I think the first panel adequately described, the problem here. And we do think that the remedies in the bill do a lot to address that. The one concern that we did have is that it would have required us to register every single merchant that sells a gift card online, which I think we'd be doing nothing but if that were the case. But we've spoken to the sponsor of the bill as well as the sponsor of the cross file and believe they are in agreement to have that particular provision removed from the bill. So with that amendment, we would urge a favorable report on the bill. Thank you.
Seeing no further questions, I think that concludes the questions for this panel. See, this is a bill about protecting the elderly. Are there anybody who's unfavorable? Up. Jason Weintraub and Robert Itten. Come on up, bud.
Just me, Mr. Chairman.
Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. For the record, Jason Weintraub here on behalf of Income Payments, a global leader in the gift card industry. We're signed up unfavorable in the bill. Over the weekend, the sponsors and the advocates shared their amendments with us, and we appreciate them doing that. For the majority of the bill, we are comfortable with the overall provisions on the amended bill. We do have concerns about the packaging language that remains in here, both in the bill as introduced and as amended. No state has set a packaging standard. States regulate gift cards in all sorts of areas, but there is nothing on the books as far as packaging this card this way or that card this way. So I would say that if there is an opportunity for 50 different state standards for open and closed loop cards, that potentially poses an issue on the manufacturing side. I would say that the language in the bill is a little bit unclear in the amended version as far as how this is going to work. It says that a card shall be enclosed in a secure package that is not easily opened without signs of tampering. It's unclear who's setting that standard. The fiscal note says that there's going to be at least 2 more people required for the AG's office to take these responsibilities on. I just don't understand who is going to look at that, how that's going to be examined. Is this going to be you put them out in the field, and if there's a spot inspection that somehow you're open to a consumer protection claim? It's just unclear how this is exactly going to work. And I would just say that fraud is ever evolving. So putting something into statute that says it shall be sealed with a PIN number or a barcode or this code covered, I can't think of another device or consumer product that legislates packaging. So imagine if you said you have to secure your iPhone using a 4-digit PIN. I just opened it with Face ID. There's not a real reason why. There's a reason why no other state has done this. We signed up unfavorable. We were just unfavorable on that main provision. Thank you very much.
Thank you, Jason. Thank you for testimony. Well, we regulate the packaging of marijuana in Maryland, so that's one. But 2, I think what's troubling is it seems like such an obvious solution. And he showed me a package that was already done. I would think all the other states would appreciate a change of packaging. So, because it sounds like the thing that needs to be done from what's been laid out. I know you're talking about a patchwork of laws, but it sounds like they're already doing it for certain cards anyway, the same maker. And if they just kind of did all the cards, we could write with specificity. We don't have, whatever the amendments are, it doesn't have to be what comes out of this committee. We can write with specificity that these must be hidden. Nothing about safety, I think what I believe the maker of the amendments in the bill we're trying to do is give you as the subject matter expert the best opportunity to do it within the vision that we're trying to, the vision we're trying to see here. I can't understand why that would be a pushback if you're already doing it, if the know-how is already there. He just gave you a demonstration of something that he believed was more than suffice.
So, Mr. Chair, there's a couple questions there. I would like to take them sort of one
Please.
at a time. To the question that was raised earlier of you're already doing this, we feel that the activation data whether that's hidden or shown to some degree is not how the fraud is actually being perpetrated. And there are anti-fraud measures with leaving some activation data available. But
would it hurt to have the activation data totally enclosed?
We don't think that is.
I understand your opinion, but I'm saying just as an assurance to just have it enclosed like the way it was where you rip it off when you get ready to scan it in, would that hurt anything?
The key here to prevent fraud is on the redemption data, and that's not the specificity that's spelled out in the bill.
But we can tighten it up. That's what I'm saying. But I would say any activation data, just having that covered, you're saying that would not help at all.
That is my understanding, and I can get back to you with
'Cause
more
you
information.
understand-
I would. I think we agree with what the sponsor is trying to accomplish here. We think a broader standard to allow the industry to innovate and come up with new measures. It's in our interest to protect these products. And we are doing everything we can to stay at the forefront of the fraudsters and the constantly changing.
And I don't want to put you in this weird environment, but what have you done in the last 5 years? It's different because I when I go buy a card, it hasn't changed in 5 years, and I don't want to put you on that. So when you say that, I don't know how anything's changed in less 5 to 10 years of me buying for my daughter and buying for my birthday parties, things of that nature. They're still stuck to the back of cards sometimes. They're still completely open where there's not even a scratch off thing. That hasn't changed.
So, Mr. Chair, I would respectfully disagree. There are nuances to the packaging that are iterations and different changes in year after year. We are constantly evolving the packaging.
And I guess without going into too much detail, it's not working. And so I think that's the concern as well. I think what you've heard is fairly clear. I know you're sitting back there and I know you're a smart guy. I understand you have a job to do, but to me, it seems like out of all the people that could figure this out once and for all be the manufacturers, and for them to push back on not covering up the activation data sounds almost insane, because it sounds like a fairly straightforward idea, something that you can already do. And I just don't understand why they can't just join with us. I understand if you're like, look, if you're going to come back to the bill maker or to my committee and say, look, the activation data itself is not enough, so we're going to protect these things this way too. But what it really sounds like is we don't want to have to do anything if we don't want to.
Mr. Chair, that is not my intention here. We think that broader, less prescriptive language as far as packaging is in the best interest of consumers to allow us to continue to innovate and not say CVV number, PIN number, activation code, or this and that. These products are changing in real time.
But I would assume as they change, knowing the concerns of the committee and the state and all the states, that you guys would continue to cover and protect other things much better than you've been doing. Because the point is, whatever you're doing, we can all agree isn't working. And that's my problem. And to say, well, let us do it now, and it's not been working. And I guess it's not a question, because I understand you yourself are not the manufacturer, but you can't sit here and tell me, let us keep doing it because it's been working. We wouldn't have this bill if it was working. So that's all the questions I have. DFH. Okay, I think then we've covered that. I believe that's all for this panel. Thank you very much, sir.
Thank you, Mr. Chair.
We're on to Delegate Pruski. House Bill 1273. Is this one of these bills that we hear? Is this a perennial bill? No. It's not.
All right, I'm going to get started, Mr. Chairman. We have two other people that will be presenting part of the panel. Good afternoon, Mr. Chairman, Vice Chairman, fellow members of the Economic Matters Committee. Delegate Andrew Pruski introducing HB 1273, Vehicle Laws, Manufacturers and Dealers, Delivery of Vehicles. To be simple, this bill is simple. If you read the fiscal note, it tells you what it does. Licensed dealerships previously had to order their vehicles from manufacturers on physical paper, written receipt. Now, obviously, we've invented the internet, we move forward, and now dealerships order their vehicles by ordering digitally, and obviously moved into the 21st century. This bill simply modernized the code, and I'll let the folks next to me provide that information in terms of technical questions. But again, it's just a simple fix. We're moving from really 5 words to 9 words. Thank you.
Hi, I'm Rob Smith. I'm with the Fitzgerald Automotive family. And thank you. It's an honor to be here, Chairman and Vice Chairman and all members of the committee. We are the history of this is Senator Levitan once helped draft the legislation that is in the consumer protection law that talks about how vehicles are distributed. And of course, he modeled it after the liquor distributors, believe it or not. And I'm sure once upon a time, they also placed a written order, and so did we. And today, it's all done electronically. It's not prescriptive. Every manufacturer has their own way of having the orders placed, or we just accept the allocation that they send to us. But the current law doesn't really reflect what we do. So we thought it was time to update this and move on. And with that, I complete my testimony and ask for a favorable review.
Thank you. I'm Franz Schneiderman, Consumer Auto Maryland. As you've heard, this is a simple bill, hopefully less controversial than some we've talked to you about in the past, but it's just to update the language of the code. Right now, the transportation code just contemplates written orders as a way of ordering vehicles, even though that's not the current practice. This updates the code to make make it reflect current practices and more efficient and more effective. So I think it's good for consumers, good for dealers. Hope you'll support the bill. Thank you.
Seeing no questions of this panel, I believe that concludes this panel. Is there anyone here to testify in favor of this bill? Seeing none, we have one unfavorable, Mr. David Bright.
Good afternoon, Mr. Chairman, members of the committee. My name is David Bright. I'm a senior attorney at the Alliance for Automotive Innovation. I represent automobile manufacturers and component suppliers. Appreciate the opportunity to speak in opposition to this bill. The bill is about a part of the industry that is not particularly controversial. As you heard from the previous panel, orders for vehicles are no longer done on paper and fax machines, they're done electronically. However, the way that this bill amends the code, it creates controversy where there is no controversy now. The current statute in Maryland simply says that a manufacturer may not refuse to deliver a vehicle to a dealer after it receives the order from the dealer. This bill does two things. It changes receipt of the order to submission of the order. Doesn't matter if, let's say, the submission is erroneous, specifies a car that can't be built because the components don't fit together, for example, creates risk there for the manufacturer in terms of what it does with an order that it received from a dealer or submitted from the dealer in this case. The second thing that this bill does is it says that a manufacturer may not refuse to deliver the vehicles if the dealer has accepted allocation of the cars. Now, it works slightly different for various manufacturers, but in essence, what's common is a manufacturer will offer allocation of vehicles to a dealer. It's like, Mr. Dealer, you have the option to order 20 cars. The dealer accepts that allocation. Sometimes the manufacturer knows enough to build the cars and ship, but oftentimes the manufacturer won't. For example, the manufacturer won't know what color to paint the cars until the dealer actually tells the manufacturer what it wants to build. And so by creating these two triggers, for when a manufacturer would violate the law if it refuses to deliver those cars in those events, creates uncertainty and risk where there is none now. So again, we don't see a problem in the current code. We don't see a problem in the current process. And so having said that, we would ask this committee for an unfavorable report. Be happy to answer any questions, and I appreciate your time.
Thanks, sir. So I guess my question would be, so the way the bill was presented, and I haven't had a chance to read it yet, was there just trying to update it by allowing it to be something more than just be in writing? Are you opposed to that?
We think it is in writing right now, but it's because it's all electronically submitted. If there is a question as to whether or not the two sides agree as to whether that is in writing, that's a conversation that I'd be happy to discuss with our dealer friends.
Testimony that you obviously, it doesn't have to be on a piece of paper, that it can actually be emailed.
No manufacturer that I'm aware of would want or require the orders to go in on paper or fax or even email. It's all a complex computer system that manufacturers use with dealers for the interaction between the two that covers everything from parts to vehicles, et cetera.
And so your concern really is with the fact that when they request something and you've read that request, that you feel that the manufacturer is now obligated merely because they've read it, or no, because it's been requested, that they're obligated to ship it.
Correct.
Even if they don't specify color, things of that nature.
Correct. Before it was very clear, when we received an order, we had to fill it. Now, under this bill, it would be if an order was submitted, regardless of whether it was properly submitted, regardless of whether it has errors, we are now on the hook to deliver something, even though we don't necessarily have the ability to do it because we don't know what it is the dealer wants us to build and ship.
And that's different than before because, I mean, I'm sure stuff has been submitted prior to this bill being that was erroneous. You didn't deliver, you know, a three-wheeled car, even if they accidentally, you know, they put 3 wheels instead of 4, correct?
That's correct, Mr. Chairman.
So how would this be any different?
2 reasons. One, when the manufacturer receives an order, it creates a date certain, you know that you have received it.
Gotcha.
And so you know that you have an obligation
And
to
that can be
build it.
done via email.
It's usually not emailed, it's usually via Dior portal, but it's electronically.
Electronic,
submitted.
apologize,
Yes, correct.
apologize. Yeah, country. Go ahead. And then what?
The second concern is with what we call allocation. The manufacturer is simply asking the dealer, how many cars do you plan to order from us? And when the dealer tells us how many cars it plans to order, it hasn't necessarily told us what it is that we want to build. So under this, it says, if a dealer has accepted allocation, you, the manufacturer, have an obligation to build and deliver that car to the dealer, even if you don't actually know what it is the dealer wants. I don't think it's the intent of this bill, but unfortunately, the way it's worded, it does create risk in an area where there was no risk before.
Well, I would ask you, sir, and I know we have other questions. If I would ask you to please meet with the bill sponsor. I'm not sure you guys are too far apart, unless you're just saying we don't want to do anything different. But if it's, again, and I'll say this for everybody listening again, once the bill is heard, it is no longer up to the parties to decide to meet in the middle, to be whether it's going to, they think it's a good idea. You don't have to come in with anything. If we identify a problem, then we'll try to fix it. But it does behoove you guys to make sure you're trying to be on the same sheet of music, because I think that this is something you may have a better understanding of than I do at the moment. Now I'll figure it out. But if you could go talk to him first to see if there's any way we can make sure, like, that if he's identified a problem and you're saying, well, it's not a problem, that's a conversation. If you're saying, well, it's a small problem and we can resolve it in these small ways, I would appreciate you working with my colleague to make sure we're not being duplicative in our efforts, and also that, you know, we don't do things that are redundant. So I appreciate your time. I believe, David.
Chairman, just off of what the chairman just finished saying, have you met with the bill sponsor?
We have not. But
Have
we'd be
you
happy to do
submitted,
so.
have you talked with the bill sponsor about any amendments at all?
Not yet, but we'd be happy to have that conversation.
I would strongly encourage you. Thank you.
Thank you, Mr. Chairman. So what I'm trying to understand is, I mean, the bill is pretty simple. You know, and aren't the orders now done all electronically?
That's correct.
So like, if a dealer at the time of sale, customers in there, goes back, salesperson goes to the manager, they hit a button to say, hey, I need to get this car. I mean, the manufacturer is receiving that order immediately. So like, I think what they're getting at with submission is that the second they hit that button, it's received. It's like an email. So like, what are we hung up here? Because you still have reasonable time to respond to the delivery. None of that was taken out. It's not like that was bracketed out of the bill. It still gives the manufacturer reasonable time to deliver the vehicle. I'm just wondering, like, what is the beef with the bill?
So to your point, I think that this is a wrinkle that we can iron out between discussions between the two sides. Our concern, as I said before, is we think that, or we worry that there is an intent between changing receipt of an order to submission of an order.
Oh, am I done? Oh, okay. All right. All right. Well, I call on Vice Chair Crosby.
Thank you, Delegate Pepe. So as we look through the bill, and council just pointed this out, we'll strike what the new language is and we'll revert back to receipt of a written order, but we'll add receipt of a written or electronic order. Are you good with that? Instead of, right.
I'd appreciate the courtesy of looking at it in writing, but it sounds like that's the reasonable path towards compromise.
We're just gonna add electronic.
Yeah, I understand.
You can look at it, of course, but.
So we'll get rid of this submission thing and, all right?
Yeah, I think there's definitely a path forward to.
Oh, there's always a path.
To there. Yeah.
Thank you.
Thank you.
Delegate Pepe, do you have any questions? Thank you. Thank you very much. Delegate Pruski, your turn again. You gotta get ready to start the meeting.
Good afternoon, Mr. Chairman, Mr. Vice Chairman, fellow members of the Economic Matters Committee. I am presenting on HB 1049, Consumer Protection Auto Renewals. The purpose of this bill is to establish a regulatory framework to govern automatic renewals, which the bill defines as a contract plan agreement between a consumer and a seller, which a paid subscription or purchase agreement is automatically renewed at subsequent term. California and Maine currently already have laws on the books related to this in the framework, and many of it is related to what I'm presenting here today. Imagine a world, though, where you subscribe for a digital product that offers a free gift or trial, and the product renews annually.
Hold on. Somebody's on, you're also on Zoom.
Okay.
No, there's somebody on. We're not.
Right now.
We are.
Okay.
You guys have this.
Can you hear me better now? Perfect. All right. Let me start over that section because this is the important part. Imagine a world where you subscribe for a digital product that offers a free gift or trial and the product renews annually. There's no disclosure or easy accessible way to view the pricing after that trial offer and know the cost for renewal. You place the order on your phone and then you decide you no longer want that product or you want to cancel it. Then you look on your phone where you place the order and you tap to find how to cancel. You search the business website that sold the product and you cannot easily find anything, the disclosure, the cost. But after 30 minutes of reviewing the site, you finally find the cancellation policy, which again was somewhat concealed and hard to find. The instructions for the cancellation provide a 1-800 number that you call to cancel. After 30 minutes on the phone of being on hold, you hang up and said, you want to know what? Is there another way to cancel? You call the number, you're done, but then you go on and see if there's a way to cancel online. When you place the order by the phone, you attempt to do so. And again, this scenario is a situation where they tells you you have to go to a desktop computer browser to cancel the product. You can't cancel it on your phone. Well, that's not an imaginary scenario. It's actually one of my constituents. And it's several that have called me about real concerns when it comes to automatic renewals. Based upon these complaints, I reached out to the Consumer Protection Division and the Attorney General's office to help guide me in creating this bill. So what exactly are the stipulations and the intent of this bill? I want to be absolutely clear. First of all, the bill prohibits a person from making an automatic renewal offer to a consumer unless the person is provided with clear terms, proximal evidence, or verbal notice of what comes for the price after the initial term. Disclosure of methods for cancellation, allowing a consumer to terminate an offer that doesn't delay, hinder, or obstruct that consumer's ability to terminate that automatic renewal. This includes widely available mechanisms for canceling that automatic renewal. Obviously, I said one of them, a toll-free number, an email address, or a postal address if the person, if the person who ordered it obviously has a PO box or whatever. But any means of communicating information also over a computer network. So if I'm able to order it by phone, I should also be able to cancel it. If you're a consumer that has accepted an automatic renewal offer with a term of at least 1 year, the required notice would be between 15 and 45 days before that renewal date. This bill prohibits a person that makes an automatic renewal from automatically charging the credit card unless it's clear and conspicuous. That's specific in the bill. We already have laws that provide consumer protection, and that's from unfair, abusive, or deceptive trade practices in other sections. What currently is unclear, though, is automatic renewals. I think everyone in this room believes that unfair, abusive, deceptive, misleading practices are misleading to consumers. Violations for this bill, to be clear, would fall under the Maryland Consumer Protection Act, like they do with other things. Also, on the fiscal note, this bill does not have an impact on state finances or operations. The Office of Attorney General Consumer Protection Division would handle this with existing resources. The local effect, the bill's imposition of the existing penalty provisions don't have an impact, and of course, small business effect. There's a couple things I want to point out, though, because there's been numerous businesses, advocates, and opponents that have met with me, and I'm certainly willing to meet with them to continue this conversation. One note I want to point out, though, is I want to thank Steve Sakamoto Wengel from obviously the Maryland Attorney General Consumer Protection Division for helping me kind of guide this. But also we do have 2 amendments. There were groups that reached out and they were concerned in particular about month-to-month contract renewals. And again, we have 2 amendments. They were emailed to the committee. I don't want to get into them. You could certainly look in your email. But on behalf of Maryland consumers, I would ask that you consider this bill and have a favorable report. And the last thing I do want to notice, which is pretty important, We did not add an amendment, but we certainly want to make this clear. If you are, for example, under the PSC, for instance, an energy retailer, you would be exempt from this bill. So if you're reviewed or under some other advisement of another state agency, as Steve can point out, you would not be included in this bill. It is only those particular contract renewals for those particular products. So I do want to highlight that's part of that. Thank you so much. And I'll turn it over to Mr. Sakamoto Wengel. Thank you.
Thanks.
You there.
Good afternoon, Vice Chairman Crosby, members of the committee, Steve Sakamoto Wengel on behalf of the Consumer Protection Division of the Attorney General's Office, here in support of House Bill 1049. We do appreciate that Delegate Pruski has introduced this bill. We've worked closely with the delegate and his staff on putting this bill together and addressing concerns that have been raised. This is an issue that we have received complaints about, quite frequently, including people who, had year-long contracts or multi-year contracts that then renewed for an additional period without them having any knowledge that their contract was about to renew. We also have a lot of complaints about people who enter into the free trials without realizing that at the end of the free trial, they don't have to do anything affirmatively. It's just going to put them into a contract that they're not aware of. And it's not till they get the bill that or see it appear on their credit card that they realize that they've been stuck. So we believe that the bill does a good job of making sure that consumers are provided notice before their contract renews or before the free trial becomes a contract. We also think that providing easier methods of cancellation is something that's very important, because we've also gotten complaints from consumers who have tried to cancel their contract and have had difficulty getting through to anybody or getting through to be able to cancel that contract. We do agree with the month-to-month amendment that this was not intended to apply to a contract that is month-to-month. So we would urge a favorable report. Thank you.
Thank you. I'm Franz Schneiderman, Consumer Auto Maryland. Yeah, as the delegate and Steve Sakamoto Wengel have indicated, this is a bill we strongly support because it really provides some important protections from a very common form of, if not quite fraud, at least abusive practices toward consumers in these in people who get pushed into subscriptions they may not really want, or into more or less endless renewals of something they may have wanted at some point but no longer want, and don't know when the charges will renew or how exactly to go about canceling them. So end up paying for them for, month after month, year after year, even for things they don't really want. This is a big source of frustration for consumers, as is well known. Better Business Bureau reported more than 58,000 complaints about subscription renewals in 2020, and a lot of consumer protection groups have acted on those concerns. The CFPB last year issued elaborate new guidance about dark patterns that push people into subscriptions they don't want. The FTC issued fairly elaborate new rules limiting subscription renewals and trying to do more to protect consumers. Those are proposed rules at this point that are under consideration, and 31 states have acted to restrict those contracts. Many of them restrict them quite carefully. Maryland's rules are fairly permissive at this point, though. We mostly limit them with respect to gym membership renewals rather than other kinds of renewals. So this bill takes some important steps to make sure people know the terms they're signing up for, know when a trial period ends, know how they can cancel a subscription they don't want, and get notification before they get another charge on their credit card. So hope you'll support the bill and add some protections Maryland consumers could really use. Thank you.
Thank you very much. Are there any questions for this panel? Delegate Adams.
Thank you, Chair. So the bill seems to be pretty broad. Does it include, like, say, Netflix or these subscriptions for television service like Comcast? So,
Yes, it would.
Okay.
Yeah, as I stated, any state agency that oversees, and I'll let maybe Steve chime in, which ones are not included. Let me talk about that.
Well, I mean, yeah, there is an exemption in the Consumer Protection Act for the professional services of a regulated industry. So to the extent that the industry is regulated, by, for example, the Maryland Insurance Administration or the PSC, with respect to their renewal policies, that would not be subject to this particular bill.
So just thinking about the consumer component of this, if I'm a consumer that has, let's just stick with Netflix. Can you imagine some consumers being annoyed by the fact that they have to affirmatively renew their subscription? In some cases, Netflix is just there until I'm done paying for Netflix, right? So I mean, I'm just curious whether or not there's a way for a consumer like me that once I sign up for something, I would prefer not to have to keep coming back or.
Delegate Adams, I don't believe that the bill requires an affirmative renewal. This requires that there be notice provided. Your contract is going to renew if you don't do something to cancel it within 15 days or 30 days or whatever the renewal period is. So it doesn't, just requires that notice and that they provide, a reasonable way for you to actually cancel if that's what you choose to do.
All right. I think that answers the questions.
Any other questions for this panel? Seeing none, thank you very much.
Yeah.
We have one more, we have favorable with amendment. We have Ms. Marta Harding.
Thank you, Madam Chair. Marta Harding. I'm here today on behalf of Assurian, which is the nation's largest insurer and service contract provider with regard to portable electronic devices, cell phones, similar devices. We appreciate the sponsors' willingness to meet with us and their willingness to work with us on the clarification of whether the bill applies to month. That was a very important amendment to Assurian. All of their products are cancelable. They're month to month. They're cancelable within the month immediately with a refund pro rata. So we think that the bill wasn't intended to get to them. The vast majority of states, if not all of them, define the service, the renewal in the way that the amended bill would do. So we appreciate that amendment. I just also briefly want to express on behalf of my other client, State Farm, our support for the amendment. I think you're going to hear a little more from APCIA. Just to clarify that insurance, regulated insurance, is not subject to the bill. We don't think it's as clear as you heard from the Attorney General's office. So we would appreciate clarifying that. But with those two amendments, we're fine with the bill and we appreciate the sponsor again working with us. Thank you.
Thank you, Marta. Any questions for Ms. Harding? Seeing none.
Thank you.
Thank you. We have another favorable with amendment virtual, Ms. Nancy Egan.
Good afternoon, everyone, with the members of the House Economics Matters Committee. My name is Nancy Egan. I represent the American Property Casualty Insurance Association. Our members write 67.1% of all property casualty insurance in the United States. I will reiterate what my colleague just said about the 30-day amendment. We really appreciate that, for several of my members do provide these type of products. But what is not clear to us is the language saying that we are not subject to the actual requirements of the bill. Insurance is a very highly regulated industry, and we are very concerned that auto and homeowners renewal, which have their own set of standards and cancellations, et cetera, need to be specifically named as not required to be in this section. We've spoken with the sponsor and with the Consumer Protection Division and have asked specific language to be added in that says that we are not subject to this provision. And with that amendment, we would be happy to discuss that further. Thank you.
Thank you, Nancy. Any questions from Ms. Egan? Seeing none. We'll now move on to the unfavorable. We have Ms. Kaylee Locklear.
Good afternoon, Madam Chair and honorable members of the committee. For the record, Haley Locklear here on behalf of the Maryland Retailers Alliance. We are unfavorable, although I probably could have signed up neutral with amendments if that was an option, but it's not. So here we go. I did reach out to the sponsor of the bill. My apologies for that being so very last minute. We have a red line that we did share with him. We're focused on 3 different areas here that we're asking for amendments from the committee on. It's not just 2 states that have passed this law, numerous states. I think it's almost half the country, actually. And California and Maine are interestingly outliers in the law that they passed. So we're asking you to align with other states. I'm going to regret saying this, but like New York is what we would be looking for. I know that's surprising for me to say. But some of it's going to make the bill better too. It adds words like timely and things like that for the consumer, where they would receive information in a more timely manner, and just clarify means of communication and give the consumer and the retailer options. So like a link you have in the bill currently, a link couldn't be included. So that's something that we would be looking for there. And then we'd also like retailers to be able to share relevant information about cancellations and incentives for continuing the subscriptions. So right now in the bill, for example, a consumer, we wouldn't be able to tell them that they're going to lose some of the information and then what they could do to rectify that. So that's something that we would like to be able to fix in the bill. And then also we believe that consumers should be able to receive notice of any sort of gift or discounts or opportunities if they continue the subscription. So we'd really like to work with the committee on that too. Finally, surprise, surprise, we'd like you to remove private right of action from the bill. It is in the place in the Consumer Protection Act title. It does open us up to private right of action. So glad to work with the sponsor and the committee. Thank you.
Thank you, Ms. Locklear. Any questions for her? Seeing none, thank you, Ms.
Thank
Locklear.
you.
That concludes the hearing on House Bill 1049. We will now move on to Delegate Amprey, House Bill 888.
All right, what you all been waiting for? Some corporate law updates. All right. For the record, Delegate Marlon Amprey here in support of House Bill 888. Madam Chair and members of the committee, thank you so much for giving me the time to speak today. House Bill 888 is being introduced to institute several amendments to House Bill 996 of 2022, which was adopted to provide statutory safe harbor procedure for ratifying corporate acts or transactions and stock that due to a failure of authorization would be void or voidable. Defective corporate acts could include an overissuance of shares or stock, a corporate action taken in the absence of board resolutions authorizing the action, and the failure to file with the State Department of Assessments and Taxation a required charter document. This bill and its proposed amendments clarify certain provisions, address internal inconsistencies, and bring the subtitle more in line with the Model Business Corporation Act, and in respect to a few provisions with Section 204 of the Delaware General Corporation Law. I believe these revisions are necessary for the proper ratification of defective corporate acts and the continuation of an effective and modern set of Maryland business laws. We want to make sure that businesses want to maintain and stay here. We want to make sure that we are up to date with our neighboring state who seems to dominate the current corporate law space. In collaboration with the Committee on Corporation Law, the section on business law, the Maryland State Bar Association, I urge a favorable report on this bill. And I have just one panel member.
Thank you. Thank the committee and especially Delegate Amprey for your attention to this bill. As Delegate Amprey well summarized, this really is a
Could you
bill.
identify yourself, sir,
Yeah,
please?
but my apologies. My name is Trey Hilberg, and I'm here on behalf of the Maryland State Bar Association's Corporate Laws Committee. As Delegate Amprey had summarized, this really is a bill to update an act that was done in 2022. And just taking one step back, the purpose of the act in 2022 was to provide a mechanism to ratify defective corporate acts, and that really supplements an option that's already available under common law. But by having the mechanism as a statutory option, it adds certainty to the process that otherwise does not exist. And as Delegate Amprey suggested, it's a well accepted and well featured mechanism in other analogs like the Model Act and the Delaware Corporate Code. So this bill, now that the 2022 enactment has been in practice for 2 years, this bill seeks to simply amend and improve and refine that new statutory mechanism. That, just by way of example, some of the changes we're proposing are as minor as fixing internal inconsistencies across the language of the code generally, making this new subtitle consistent with the rest of the code, to more substantive things to reinforce and clarify language, things such as in instances where approvals for these acts may be different at the time of the defective act and the time ratifying. We're proposing to add language that clarifies whatever the higher standard is would apply in that instant. So it's just one example, and we'd ask for favorable support of these amendments.
Thank you, Mr. Hilberg. Are there any questions for the panel? Seeing none? Thank you very much. We did have an unfavorable vote. It was a mistaken sign up, so that will conclude the bill hearings for House Bill 888. Our next and final bill, Delegate Amprey, House Bill 1275.
I think I have some panel members here. Come on up, guys. Another riveting topic, standing. All right. Well, it's like I'm in law school today. For real. Yeah, this is taking me back. All right, thank you, Madam Chair, members of the committee. For the record, Delegate Marlon Amprey here in support of House Bill 1275, Corporations and Associations, Vehicle Laws, Manufacturers and Dealers, Standing of Dealer Associations. House Bill 1275 is being introduced to allow a vehicle dealer association on behalf of itself, a vehicle dealer or a group of vehicle dealers to bring suit to the manufacturer or distributor, etc., to recover damages and reasonable attorney's fees. This bill will allow a vehicle dealer association, distributor, or factory branch to request an administrative hearing to resolve a dispute under any provision of this title between a dealer or a designated dealer successor or dealer association and a manufacturer, distributor, or factory branch. See clarification of interpretation of any provision of this subtitle. This bill is important to support Maryland businesses such as vehicle dealer associations, so they have the right to protect themselves during legal disputes. In Maryland, cars are a necessity of life to help our citizens get to work, home, and independently live their lives. It's also an important industry in our state. The Maryland Department of Transportation reports that 2023 alone, new used car sales totaled over $19.5 billion. I share this belief that business dealers should have avenues to protect themselves and their businesses during disputes. This bill supports timely and smooth processes for seeking justices on behalf of dealer associations. And with that said, I ask for a favorable report, and I will let my panel give more details on the bill and why we need it.
Madam Chairman, members of the committee, my name is Peter Kitzmiller. I'm the president of the Maryland Automobile Dealers Association. We represent 300 franchised new car and truck dealers and their 20,000 employees across the state of Maryland. Here today in support of House Bill 1275, Delegate Amprey did an excellent job of kind of summarizing the bill. Maryland, along with 49 other states, has a fairly extensive section of law regulating the relationship between automobile dealers and manufacturers. The issue with these laws is they're not self-executing. And so a dealer, if they believe that a policy or procedure of a manufacturer violates law, has to either file a complaint or file a lawsuit. Most dealers are not going to be willing to do that. They are concerned about retaliation. What this bill will simply do is allow the association to avail ourselves of the process that MVA has set up, where the association could file a complaint. Then it would be referred to the administrative law judge, and we would be seeking some kind of declaratory relief. A couple of things that I think potential concerns about the bill. Number one, increased litigation. There are 9 states currently across the country where the dealer associations have standing. None of those states has seen any increase in litigation. And again, primarily, we're looking for declaratory relief. I know the bill does talk about damages, et cetera. We're not looking to collect damages. It would be simply availing ourselves of the MVA process so that we could get some of these issues clarified instead of having to come to the General Assembly every year and trying to get the language exactly perfect. So I think this is going to benefit everyone that we're involved. And again, Nothing's changed here. The burden of proof doesn't change. We didn't add anything to the law. The dealer association would have to go in front of the administrative law judge and make our case. And either we're going to prevail or we're not. It doesn't change anything with regards to the substance of the law. And so therefore we'd ask for a favorable.
Thank you, Madam Chair, members of the committee, Bill Castelli. And I'm here on behalf of MATA and also the Washington area new car automobile dealers. And we are in support of the legislation as well. I did want to address one of the concerns that was raised in terms of whether this establishes some kind of new association standing. But there are certainly within the Maryland Code instances where associations have been given standing on other issues. This is not novel, it's not new. And we do think it will provide an opportunity for some of these disagreements over the franchise law to be worked out outside of this committee room. So for that reason, we would encourage a favorable report.
Madam Chair, members of the committee, good afternoon. For the record, Brad Rifkin on behalf of MATA and WNATA. Echoing Mr. Kitzmiller and Mr. Caselli's points, and thank you to the bill sponsor. We heard over the last couple of years, that this committee would prefer that these disputes don't take place here. So this is an alternative to that, and we would respectfully request a favorable report. Thank you.
Thank you. Members, are there any questions for this panel? Delegate Pippy.
Sure, just real quick. Maybe one of the industry folks could answer. So the definition of association, is that pretty clear on who could do it? Because I know there's like a Maryland Association of Dealers, there's Washington Metro, there's
no.
So is it national? I mean, so who? I mean, I think the definition says it's primarily owned by composite dealers. That's not going to be like some offshoot because there's official NADA folks. I'm just trying to make sure that this wouldn't apply to a whole bunch of different people.
Correct. I think the definition is clear, but if we can clarify, if we need to clarify it, I did look at a couple of the other states because Delegate Pippy, I think it's a valid question. I was looking at it last night. A couple other states have a specific criteria. Maybe we could add that. I think it's clear, but yeah, the intent is for a dealer association to be able to do this.
The official one, not like,
yes, yes.
Somebody else who just was working for the interests of dealers, because that could be like 100 different people, in theory. Okay, all right, that was it. Thank you.
Thank you.
Any other questions from the members? Seeing none, I have one. Brad, I don't see Michael, but are you here?
I'm here for Michael.
For Michael Johansson. Okay. Thank you. That concludes the bill hearing on House Bill 888. Oh, I'm sorry. We do have an unfavorable, Delegate Ampry.
I was trying to get us back on schedule as far as ending by 4. But,
if he's here, David Bright, and he's here.
I'm here. Thank you. I appreciate the time. Again, for the record, David Bright, the Alliance for Automotive Innovation. Appreciate the time to speak in opposition to this bill. I do want to state at the outset, the relationship that manufacturers have with their dealer bodies is a positive one. Manufacturers like their dealers. We understand that we depend upon each other for our mutual success. What we don't understand is why a state dealer association would need standing to hail us into court, even if that dealer association is the only plaintiff. Because the dealer association is not a party to our franchise agreements. They're not a party to the contract between the manufacturer and the dealer. And notwithstanding what you heard from the previous panel, there are disputes between us from time to time. Dealers are not afraid to sue manufacturers. And frankly, the attorneys who represent both of our sides have sent plenty of children through college based on the amount of litigation between our two groups. What's concerning is that if you've got dealer associations who are able to bring an action against a manufacturer, does that create more controversy or does it lessen it? I would argue that it creates more controversy. Again, the dealer association is going to be representing dealers who have varying interests in the outcomes of those cases. Whether it be one group of dealers who's participating in an incentive program that the dealer association wants to challenge, other dealers are not. Some dealers representing one brand, some dealers representing another brand. And then amazingly, to go so far as to actually allow the dealer association to be awarded money damages, even though the association itself was not harmed. That's again, incentivizing litigation when there was no incentive beforehand. Again, we think this is going to result in unnecessary strife in our industry. And we also would submit respectfully that this committee think about what that's going to invite other special interest groups to want from the General Assembly in terms of special standing rights of their own in Maryland. So again, I appreciate the committee's time today. I'd be happy to answer any questions.
Are there any questions? Delegate Adams.
Thank you, Chair. So, I mean, we've had these subjects for a few years now. I think before it was environment and transportation. And as a rule of thumb, these bills relate to the Maryland General Assembly trying to weigh in or decide when there's disputes between the dealer and the manufacturer. And sometimes I just wonder, is that because the manufacturers have so much weight and leverage in the relationship that it's almost like it's the manufacturer with the General Assembly and the dealer sort of trying to balance the scale? Do you not see it that? I mean, and that's a generic question. I'll get to a more specific question on the bill, but I think the bill's here because there's this thought or concern for the dealers who may have a legitimate complaint weighed against a manufacturer of size and wherewithal, both with legal and financial ability to pursue and defend. So, I mean, do you agree generally with what I'm saying as a matter of principle, or do you disagree?
I would respectfully disagree. I think in the 21st century in particular, the franchise agreements between manufacturers and dealers have been so thoroughly regulated by state legislatures around the country. Really every single aspect of that relationship, you know, it's the actual contract is secondary almost at this point. And part of that is because dealers, you know, are influential in state capitals. We don't have a manufacturing plant in every state or every district. And I think over the recent decades, franchise legislation around the country has very much balanced that playing field. I don't think it's a situation where manufacturers can come in and throw their weight around. For example, in Maryland, just like any other state, we're limited as to where we can build a point, or if we want to move a dealership, we're limited there. If we want to no longer be in business with a particular dealer, that's not an option. We've got to have actual good cause that we can show to either end a contract or just not renew a contract. I think that the lengthy regulations at this point have more than balanced the playing field between our two parties.
I understand. I respect your answer. I do think that some of the subject matter in the bills that we hear have a tendency to get very controversial. I mean, even for us as just policymakers, we're not even market participants, but there's weight and consequence to a vote for or against these subjects. So, you know, the bill's coming, I think, through the lens of you know, granting some additional power to the dealers to conduct what they think is the best interest of their business model. So I'll just ask you the last question, because I mean, I'm probing here. I don't know that I have an opinion on the bill coming or going, but if I was fortunate enough to own a dealership to be able to sell one of the national brands, and my family has been around for many, many years, and now it's my generation's turn at it, and I had a real beef with one of these manufacturers, would I actually go to the mat to defend my turf, or would I be fearful that I would lose perhaps my working relationship with that national manufacturer, or even worse, could I lose my franchise? Do you think, could you see a scenario where a owner would adjust their behavior based on that sort of leverage with the manufacturer against the dealer?
Respectfully, I don't. And I've heard dealers make an argument that they would not file an action or make a complaint for fear of retaliation. And the simple fact is that a manufacturer can't really retaliate at this point. We can't take away the franchise because we don't like you. We can't not give you cars because we don't like you. We can't not allow you access to an incentive program because we don't like you. It's under the state law. We cannot discriminate amongst any car dealers. Okay? We've got to treat you the same as everybody else. Okay. And we also can't say, drop in another point across the street from you to compete with you. Again, that's also prohibited. So, you know, there's no interest for us in being evil for the sake of evil. And
I don't think you're, I think you're missing the point of my question was not to create a position statement against the manufacturer. It's to simply say, do you accept the premise that there is a balance or a scale? And I don't think this is controversial. You know, the legal wherewithal, the financial wherewithal of a national manufacturer when it comes to a dispute with a dealer. So I think the bill, if I understand it correctly, and again, I'm not going to commit to whether I support or oppose the bill, but the bill's coming through the lens of if a dealer is going to have, or dealers are going to have success in that venue, they're saying that they may want the association's involvement, not just a single dealer who's willing to stick their head out of the weeds and hopes of not getting it lopped off. That's in. I think you've answered it. You and I are going to go back and forth on this, and I appreciate your responses. Thank you.
Thank you, sir.
Delegate Aaron's.
Something you just said, this was a few years back when the dealers we crunched about a bunch of dealers. A lot of people went out of business. A lot of dealers were selected over others. Dodge did it. I think Chevy did it. Is that something he's referencing? You know, did some of those guys actually said that they upset the manufacturer? That's why they were picked to be out of business.
Yeah, Delegate, I think you're referring to terminations that happened during the bankruptcy during the Great Recession. Is that correct?
Yes.
Yeah. The manufacturers themselves did not have as much control over what their dealer body was going to look like. Two manufacturers, as you recall, did go through bankruptcy then, General Motors and what was then the Chrysler Corporation. The federal government was actively involved in telling us what that business was going to look like going forward. And I know dealers were involved in lobbying that as well. But again, that was, I would say, an extreme case. You know, again, the only way that those companies were able to actually end those franchise contracts was through bankruptcy law, not through the standard dealer termination law that's governed by Maryland.
Well, they you know, and again, I only heard one side of the story back then, and they were sitting back saying we were singled out, but that's, everybody's a victim when it comes down to it. I just didn't know the whole story. But thank you for your answer. Thanks.
Any other questions? No? Okay. Thank you very much.
Thank you.
That concludes the hearing on House Bill 1275. Members, House Bill 1135 was withdrawn. And final message from the chairman, we have our venue this evening and you are expected and appreciated. Having said that, have a venue mention.